Provisional cotton. ಏನಾದ್ರು ಹೇಳಿದಾರ?
ಸಿಂಗಲ್ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಇರೋದ್ರಿಂದ ಏನೋ ಮಂಡೇ
ಅಲ್ಲ ಅದಕ್ಕೆ ಹೇಳ್ಬಿಡು. List number 2, any of you are waiting? Monday. Those matters will be repeated before the same bench on Monday. Serial number 6. Because other side is not there. If they come and pressure you, can make the same request for the same bench on Monday. All right? Right. Notice ಹೋಗ್ಬೇಕಾ? RFA. Serial number. How many LRs are there? 4. Serial number 2, list number 2 number. Issue notice of IN number 1 of 2024 to the proposed LRs of deceased respond number 4. Returnable by return by list.
21st March.
21. List on returnable by 21. List on 20.
Serial number 1 in the second list.
One
Place for a week's time to compare.
Serial
number 1.
Serial number 5. Memo for filing additional documents. Final hearing. All right. What we said, it applies to you also. This is final hearing. Go and seek the adjournment before the same bench.
Serial number 1.
No, serial number 1. At request third time and at request 1 week time. Serial number 1 and list number 2. At request 1 week time is granted to do the either rest of the notice. List on Monday. This list number 1.
List number 1, page wise. Page 1, till number 1 to 6. Page 2, till number 7 to 12.
List 1, serial number 2, my lord. List 1, serial number 2. Pray for.
We are hearing only astral wise. Oh, ಈಗ ಬಂದ್ರ? Yes. Not on uniform. ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ.
Apologize.
Yes.
My lord, serial number 2 weeks time may be granted. I have to give one additional booklet, my lord. It's
This is legal services, huh?
How the Sami?
Standing Council Legal Services said.
Yes, my lord.
At request 2 weeks. At request 2 weeks time is interested. Yes.
No, oblige, my lord.
Page 2, till number 7 to 12. Page 3, till number 13 to 18. Page 4, till number 19 to 21. Page 5, till number 22 to 28. Page 6, till number 29. Order, till number 1. Kartik Kumar K, SPP.
Appellant's counsel is absent. Last year, 3 weeks time is granted. No representation for the appellant. Appellant or appellants. Appellant. No letters. The records show that on previous hearing date also, there was no representation. There was no representation for the appellant. 50,000 fine. And he was in custody and no answer is released. Appellant accused. ಇನ್ನೇನು ಬಂದಿಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 760,000 ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೌಂಟಿಂಗ್ ಕರಾಚಿ 400 something, 400 something is in custody ಅಂತ ಬಂದು. 400 something is in custody. 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 ink patient. He has set off ಅಂತ order ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ. He is in judicial custody since more than 4 years. He 2017 ಅಲ್ಲಿ 2021 ಅಲ್ಲಿ more than 7 years interim for us. The appellant is in judicial custody. Therefore, the matter is referred to High Court Legal Services Committee for providing free legal aid to the appellant. Please note. It is
Number 2 adjourned. Number 3, M. Shashidhara, CP.
ಕಾರ್ತಿಕ್ ಕುಮಾರ್ ಅನ್ನೋ ಬರ್ತಾರೆ ಇಲ್ಲಿ. Who is ಕಾರ್ತಿಕ್ ಕುಮಾರ್? ಬರ್ತಿರ್ತಾರ ಇಲ್ಲಿ? ಸರ್. There are other appeals. Accused number 1, Raja was preferred criminal appeal number 1148 of 2017. Raghu 1177 of 2017. So allowed ಅಂತ ಇದೆ. So connected appeals are allowed. So thereafter he takes this chance. Accused number 2, Pratap was preferred and that is allowed. Objections along with there are office objections to comply. It request 1 week time. No, ನಾಳೆ ಅಲೋ ಆಗಿದಾವೆ. ಅಪೀಲ್ ಹಾಕೋದೇ ಅದಕ್ಕೆ ಹಾಕಿರ್ತಾರೆ, ವೇಟ್ ಮಾಡ್ತಾರೆ ನೋಡಿ. ಈಗ ಅರ್ಜೆಂಟ್ ಆಗ್ಬೇಕು ಯಾಕಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಅಲೋ ಆಗಿದೆ. ಆಯ್ತು. Put up the records of the connected criminal appeals. Yes. Please talk for 1 week.
Number 4, Shashidhara, PM. CP.
There is one more appeal. Then we'll direct to list this matter along with the other. You are withdrawing this appeal? Okay. So they are not informed you about this. What is the connected matter? 2023. So your appeal is first and that appeal is subsequent. Millana consultant appellant submits memo reporting that the appellant got filed another appeal in criminal appeal number 1309 of 2023 through the High Court Legal Services Committee or through the High Court Legal Services Committee, and that appeal is already admitted. Therefore, he seeks withdrawal of this appeal. Regarding the same, the appeal is dismissed as withdrawn. Recording the memo, appeal is dismissed as withdrawn. Who accused? He was in custody there. An accused is in this. Delaying. Hadasana number 1 of 2024. Then 24. 2, 3, 4. Sorry, 1 of 23. The appellant was in judicial custody during the trial, and post conviction also he is in judicial custody. In post conviction also he is serving sentence. The same is pleaded as ground for the delay, accepting the same delay of 591 days. 591 days in filing the appeal is condoned in the interest of justice. I am 1 of 2023 is disclosed accordingly. What is the case? There were so many injuries. Hmm. She was also the second wife. How the first wife died? ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರಾ? Her first wife died or abandoned? With someone. What was the age of the children? What was the age of the children? PW2 and 3? PW2 is the son. No? He also sustained injuries. So incident has taken place in his house. Return ಬಂದಾಗ ಅಂತ. And he was standing near the sawmill on Mahadeva. And they were walking near the rice mill of one Mahadevaya. So case is based on eyewitnesses, that to his own children. And one of the sons suffer. And ವಜಾ ಮಾಡಿ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. ನಾವೇ ಓದಿದ್ವಲ್ಲ. ಹಲೋ. The matter requires detailed consideration. Admit call for TCS. Paper which shall be prepared within 4 weeks from the date of the receipt of the TCS. Order summary number 2 of 2023. The appellant accused is convicted for the offense under section 3 and 2 IPC. ಮತ್ತೆ ಮಗುಗೆ P24 ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದಾದ್ರೂ ಆಗ್ತಿತ್ತಲ್ಲ, ನೆಗ್ಲಿಜೆನ್ಸ್ ಆದ್ರೂ. ಕರೆಕ್ಟ್. He as the father, ಜುವೆನೈಲ್ ಜಸ್ಟಿಸ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಏನಾದ್ರೂ ಇದಾಗುತ್ತಲ್ಲ ಅಫೆನ್ಸ್. Our people have more sympathies with persons who commit all these kinds of things. If not treated, if there is no intention, it constitutes some other offense. And sentenced to imprisonment for life on the ground that suspecting the fidelity of his wife, he committed her murder by stabbing her. It's also the records also show that prima facie show that the records show that the trial court held that the appellant inflicted injury on his son also when he went to his mother's rescue. The said injured son is the eyewitness for the incident. The injured son and Ibru, PW3 and 4, Preeti Kirti. PW4? Correct. He is the daughter. No? The appellant's other child, PW3, is also an eyewitness. Considering the material on record and nature and gravity of the offense, it's not a fit case to. So we can considering that the appellant was not granted bail during the trial. Considering the aforesaid facts and circumstances and gravity of the offense, it's not a fit case to grant suspension of sentence and application rejected. Please after 4 weeks. Admit, call for records ಎಲ್ಲ ಆಯ್ತಲ್ಲ.
Addition to the text to be the night of the 13th August 2020, a month of water sounds around 9 o'clock in the night. Thereafter, the very next day of the August 2020, is longer than and said that something was happening to my wife. She rushes to the house. She sees that the victim is lying on the floor of her hand. She knows the hand of the deceased because the body is falling and she notices that the man has passed away. Thereafter, she rushes to call her husband. Then she goes to the police station.
Within 1 year of marriage. Within 1 year of marriage. Yes, what was his explanation for that? Cause of death.
The entire case of the subject is supposed to have evidence. And when I could read the note, there is no single direct eyewitness. The main witness alleged that there is a dowry against him. He has won the information. She has not party. He doesn't know his husband. He's a hearsay witness because he has not seen anything. He says that my wife told me they were fighting. My wife told me that she was not by the book. He's a completely hearsay witness. Despite that, he has not party.
Correct. Now the trial court has convicted him for 302 and 304B both. What is the Is it whether the trial court held the death to be homicidal or suicidal? Because 302 also, according to the doctor, what is the cause of death? Where the medical evidence is discussed? Page number 70. Asphyxia as a result of constriction of neck, ligature strangulation. Whether she was found hanging when no, she was on the floor.
All the witnesses are not partially hostile. All the witnesses are not hostile at the police. The constable is there. Apart from that,
Correct. Now death has taken place in your house. It was unnatural, whether suicidal or homicidal. Whether you reported the matter to the police.
my lord, I was informed that I should call there are extreme material discrepancies in the entire state. So I just called out to
Yes, sir.
2001, not chief examination says around 7:30, the accused has left from the factory. So the accused was left from the factory on 14th of August 7:30. Later she herself contradicted saying 8:30 I was following his house in the house. Then 9 o'clock the accused left. Timeline at this point of time. Again in one cross examination by the accused lawyer, she said that the accused left at 8:30. And all material comes to timelines is what happens. Here, apart from that, she has done partial hostel. She, how material discrepancies that are available, which was not found. She said that examination, the alone came informed that something happened to my right hand is run the bed. I rushed to go there. Once I rushed and went there, I saw something in the oven and I saw some people from the side. Stated in the chief exam. Cross examination probably takes a 180. It says that after a lot of the students came to my house and informed me that something like that. This is a material inconsistency in your record.
Correct. See, the incident has taken place during the in your house during night time, where you ordinarily resided. You had whether you have disputed your being there.
My God, like witness on admission, I am left with kind of law.
Correct. What was your defense? Did you take the plea of alibi?
My God, the accuser is not denied on
Yes. He has not taken the alibi. Plea of alibi. And you were not granted bail during the trial.
he has not approached the High Court item.
Not High Court.
This one I was completed. After that, he got to get his legal and effectively he has not applied for the High Court. They have been in incarceration since 2020. But why I bring this point is, by the story of the prosecution, I have left the house at 9 p.m. Body is discovered at 7 a.m. in the morning. And the postmortem report has a material omission if they do not specify the exact time of it. Postmortem doctor that you have not specified the time of death. If they have admitted in the trial that you have not specified the time. So the time of death is still not specified. And it is admitted that at 9 p.m. I have left my house.
We ask you specifically whether in your 313 statement you have taken any. Then 106 you have to explain. Anyway, because he was not granted bail even during the trial also, we do not find any ground now to grant suspension or something. Yes. So if you want referring to the witnesses' evidence, then we have to see the records. For that, records are required. Either you submit the copies or we'll call for the records, then you can argue this. If you want to argue in detail, referring to the depositions, etc., because we don't have a deposition for us. Yes. Yes, yes. Yes.
Like I said, in any criminal case, this criminal case, it is based on circumstantial evidence. Second is lasting memory. Now, it has been amply established by the Honorable Supreme Court that the chain of circumstances should be no other presumption except the chain of evidence. But in this case, there are multiple possibilities. The chain of events is very, very deep because husband refers to motive they alleged dowry debt. My lord, the only witnesses speaking about dowry are the uncle and aunt, that is PW 5 and 6, who are the uncle and aunt of the deceased. They say that yes, he was married. If you read the chief examination, the statement, it's a copy-paste statement. But the problem with this copy-paste statement is both of them are residing in Andhra Pradesh. They are not residing. They both say that yes, a few months back, the accused and the deceased visited our house. Accused demanded 5 lakhs of dowry. We are not to stay for years. And thereafter, he has left for his village. And we have promised to give him back. Now, both make the exact same statement. However, they both reside in totally different cities in Andhra Pradesh. How can I decide on the same place with both of them in two different places for something there and it is a very clear way that this is the same copy paste. So the motive factor is ruled out here. Apart from that, the last thing there is like I said, the time of death is uncertain. If the time of death is uncertain, the time of death is out of the country. So it is for the prosecution to prove that.
So there is extrajudicial confession also before PW, according to them. Page 16 note. She has turned hostile, that's what she argued. But it appears in the complaint there is a statement that he confessed that. And ligature material was that nada.
I don't the murder and sacrifice of homicide. Appointed the lion left the house. There is multiple possibilities of worse after that. And
But complaint says that you locked it from outside and went to the factory.
she locked from outside.
She was there inside. Why he lashed when wife was inside?
Some people have a tendency.
That tendency creates doubt. Yes. Ordinary man of ordinary prudence will not do that.
But there is a common practice that when the husband leaves at night,
No, he asked her to lock it from inside, not from outside. Yes. Yes, yes.
but the witness who states that has turned hostile. I get that there is no direct.
That you have said, in such cases, direct eyewitnesses possibility is very less because husband and wife alone were living.
And the witness has turned completely hostile. Not even one.
Parents are supported.
Parents are not supported.
Then you, so whom you referred? Uncle and aunt. Whether she had parents or not. So her guardians are supported.
And they, like I said, have exact copy paste statement. And in the end, CW6 also says that I heard from CW1 that this murder was done due to dowry. So it is not that he has a direct information, it is only hearsay. So based on what CW1 has gone to court, he did not directly know this. And the statement they make, they say, exact copy paste statement. Because of this copy paste tendency, they have particularly made a mistake in noticing that both of them are said and they both are staying in different cities. Not possible that the accused stays with them on the same dates in two different cities. However, this is an entirely future confession. I request this fellow, he is an only son. Father is a widower. He is an aged person suffering from severe health ailments. He is unable to walk. His village is located on the Andhra Pradesh-Odisha border. May kindly be not come here. They are ready to produce anything. He's already been incarcerated for almost 3
There was an injury on the upper eyelid. Abrasion on the front, over the front of left shoulder. And earlobe, there was an injury on the abrasion. Okay, left side of the neck. Neck injury number 4 and 5. How do you explain that? Yes. So you claim total innocence. You do not say whether it is a homicidal, suicidal. That was not your defense.
No, my lord, we say that I was police. Because the defense that it was suicide, I think nothing is supposed to.
You have taken the defense that it was suicide. Yes, that's all. Okay. Any question? She has turned hostile on the whole.
Yes, some hostile.
Outlaw's. Hostile regarding which she supported, which she did not support.
The timeline is in the system, my lord. 7:30 she says everything is good.
Well,
Later she says 8:30 I have to
now
work.
let him say. He said that she is partially hostile. Which materials is supported? Only no explanation is offered against the incriminating evidence. All right, ma'am.
Panchayat is also not partially hostile. He says that I want to offer this. And he says he doesn't know anything about the photographs.
They said only that is about information. What information complaint contained? Yes. She had already lost her silence.
Panchayat is also a strong hostile and he says that I overheard the everybody only overheard someone. I only request for the one of the person, or there were direct messages, even the subconscious messages of all for participants. Forward, no follow, no not say time of death. And between so
How many times will you repeat that?
pending is the only son of his father.
Okay, 1 year, within 1 year of her marriage, in his hands, and complaint is that philosophy follows. Worship outside and not 6. Matter requires detailed conditional question. Admit false TCRs. Paperwork shall be prepared within 4 weeks from the date of the receipt of the TCRs. Orders in end of 2024. Minor counsel for the appellant. Government submits that the case is based only on the circumstantial evidence and a large number of witnesses are not supported. She further submits that the appellant is in judicial custody since 20th evidence 15 Bandila. 20th August. Why he was not? The incident has taken place on 15th. Why he was arrested on 20th? He went absconding.
He was called from the bus stand and the same direction.
Bus stand, but the incident is on 15th. You said he was arrested on 28th. Where do we find that? In the film? Since 2020. A judgment is read Bandila 2020. Therefore, the interim judgment is an interim order sentence be suspended and he be granted bail. Lawyer from the prosecutor submits that though the case is based on circumstantial evidence, the death has taken place. Taken place within 1 year of the marriage, and the evidence of the witnesses show that the accused is the author of the death. The evidence of the witness and circumstances. Next paragraph. Where do we find that?
The deposition of capital.
Page number? Where are you?
Deposition.
You are holding the deposition. We don't have the deposition. Judgment elevation. All right. We said 2020. No, August 2020. August 2020. Like he's in custody ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, August 2020. The page 19 at internal page 19. ಗೊತ್ತಿಲ್ಲ, ಓದಿ ಅಂದ್ರೆ ನಾನು ಓದಿ ಸಹಿ ಹಾಕಿದ್ದೇನೆ ಅಂತ. Entire suggestions, questions put forth. It's seven. Correct. She did not dispute that her relatives supporting the case, but she was telling that they were there. How do they know harassment? Yes, they were in that we asked.
This is the author of it.
And he doesn't deserve any indulgence. The appellant accused is convicted and sentenced for the offenses punishable as from penal to penal for B. So 298A penal to penal for B of IPC and section 3 and 4 of the Dowry Prohibition Act on the ground that within 1 year of his marriage with the victim, he subjected her to cruelty in connection with his demand for dowry and committed her murder by strangulating her with her petticoat blood. The death has, there is no dispute about that being taken place in the house of the accused. Within 1 year of the marriage, the death being taken place within 1 year of within 1 year from the date of the marriage in the house of the accused where himself and her deceased lived together. Himself and deceased ordinarily resided together. Medical evidence shows that apart from the strangulation, apart from the ligature injury, there were other external injuries on the dead body of the victim. The aunt and uncle of the victim have supported the theory of supporting the case of harassment in connection with demand for dowry. The accused has not, the record shows that the accused did not explain, accused in his examination in district court office did not explain the death. Explain the cause of injury. He was not granted bail during the time. Considering the material on record and the gravity of the offense, it's not a fit case to grant suspension of sentence. This application is rejected. Please refer for 4 weeks. Yes. We have extracted your arguments. Don't worry. Don't get disheartened by one rejection. Mr. Hanmantrayappa ಅವರಿಗೆ ನಾವು ಕೇಳ್ತಿರೋದು ಯಂಗ್ ಲಾಯರ್ಸ್ ಒಂದು ಕೇಸಲ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ಆರ್ಡರ್ ಆದ್ರೆ ಆಮೇಲೆ ಅವ್ರು ಬರಕ್ಕೆ ಬೇಡ ಅಂತಾರೆ ಅಂತ ಹೇಳಿ ಪೇರೆಂಟ್ಸ್ ಆರ್ ಕಂಪ್ಲೇನಿಂಗ್ ಬಿಫೋರ್ ಅಸ್ ಸಮ್ ಆಫ್ ದ ಅಡ್ವೊಕೇಟ್ಸ್ ಅವ್ರ ಮಕ್ಕಳು ಬರ್ತಾರಲ್ಲ ಬಾರ್ಗೆ ಒಂದು ಕೇಸಲ್ಲಿ ಅಡ್ವಾನ್ಸ್ ಆರ್ಡರ್ ಆದ ತಕ್ಷಣ ನಂಗೆ ಬೇಡವೇ ಬೇಡ ಲಿಟಿಗೇಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಏನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವೇನೋ ಹೇಳ್ತೀನಿ P6 and P7 are P6 and P7. Just a minute. Other than P6 and P7, whether they were admitted documents? One second. There were 2 places of offense. One place where he stabs, the other place where he goes and falls down. P6. P10, P8, P6 and P7. ಯಾವ pole ಅಲ್ಲ? Some wires are there, right? Telephone pole in electric pole. ಅಲ್ಲ ಒಂದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ ಬಿಕಾಸ್ ದಿಸ್ ಫೋಟೋಗ್ರಾಫ್ ಇಸ್ ಟೇಕನ್ ಡ್ಯೂರಿಂಗ್ ದ ಡೇ ಟೈಮ್. ಫಸ್ಟ್ ಫೋಟೋದಲ್ಲಿ ಒಂದು ಕಂಬ ಇದೆ, ಅದು ಏನು ಸಮ್ ವೈರ್ಸ್ ಒಂದು ಕಂಬ ಇದೆ, ಅದು ಎಲೆಕ್ಟ್ರಿಕ್ ಪೋಲ. ಅದ್ರ ಕೆಳಗೆ 11:30 ಅದು ಆನ್ ಇತ್ತು ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಸಪ್ಲೈ ಇತ್ತು. ದೇರ್ ವಾಸ್ ನೋ ಡಿಸ್ರಪ್ಷನ್ ಆಫ್ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಅಂತ ಕೊಟ್ಟಿರ್ತಾರೆ. ದೀಸ್ ಲೈಟ್ಸ್ ವೇರ್ ಆನ್ ಅಂತ. After 20 days, more than 20 days it seems. Why this IO got in? It appears IO had a doubt that these witnesses may not support. Illandre immediately ಮಾಡಿಸ್ತಿದ್ರು. What are you telling? Requisition. See, after 20 days of more than 20 days, more than 20 days, he gets them examined before the magistrate. ಅಲ್ಲಿ ಅವರೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ, ಇಬ್ರು ಲಾಯರ್ಸ್ ಇದ್ರು ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಅದನ್ನ ಕೊಡುವಾಗ ಹೇಳಿದಾರಲ್ವಾ ಆ ಸ್ಟೇಟ್ಮೆಂಟ್. ಅಲ್ಲಲ್ಲ, ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಕ್ ಹೋದಾಗ ಅಲ್ಲಿ ಇಬ್ರು ಲಾಯರ್ಸ್ ಇದ್ರು ಅಂತ ಬಂದಿದೆ. You have asked whether there were police. They say that there were 2 lawyers ಅಂತ ಹೇಳ್ತಾರೆ. 2 lawyers in public prosecutor ಇವರ ಯಾರು ಗೊತ್ತಿಲ್ಲ. Why the lawyers were present when they went there? And that was not clarified in their cross-examination. Sorry, by re-examining them. Who were those lawyers? And moreover, when the witness is supported, what was the need of getting that 164 statement again marked? Correct. No, they support ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾರ್ಕ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಸಪೋರ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಯಾಕೆ ಮಾರ್ಕ್ ಮಾಡಿಸ್ಕೊಂಡ್ರೆ ನಮ್ಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. Is there any need after supporting witnesses supporting the prosecution version again to get the, because it was statement of living person. Because incident takes place at 11:30 according to them. Even ಸಿಟಿಗಳಲ್ಲೇನೆ ಈ ಎಲ್ಲ ಎಲ್ಲಿ ರೆಸಿಡೆನ್ಶಿಯಲ್ ಲೊಕ್ಯಾಲಿಟಿ ಇರುತ್ತೆ ಎಕ್ಸೆಪ್ಟ್ ಸ್ಟ್ರೀಟ್ ಲೈಟ್ಸ್ ಆಫ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಉಳಿದದ್ದನ್ನ. ಹೌದು, that's what they argued. ಬೇರೆಯವ್ರನ್ನ ಯಾರನ್ನ ಇಂಡಿಪೆಂಡೆಂಟ್ ವಿಟ್ನೆಸಸ್ ನ ತಗೊಳ್ಳೋದಿಲ್ಲ ಅಂತ. And these witnesses say nobody came forward even to offer water to this dying man. ಅವ್ರ ಮನೇನೆ ಎಷ್ಟು 100 ಅಡಿ ದೂರದಲ್ಲಿತ್ತು ಅಂತ. 100 meters ಇವ್ರದೇ ಮನೆಗಳು 100 meters ದೂರದಲ್ಲಿತ್ತು. ಅಕ್ಕಪಕ್ಕ ಅವ್ರ ಅಂಕಲ್ಸ್ ಹೌಸಸ್, their uncle's houses were also there ಅಂತ ಹೇಳ್ತಾರೆ. But despite that, this Manu Kumar phones PW1 comes and then they shift him to the hospital. ಸ್ವಲ್ಪ ಅಂದ್ರೆ scope for suspicion ಇದೆ ಇದ್ರಲ್ಲಿ. ಅಷ್ಟೇ ಅಲ್ಲ, ನೀವೇನೋ ಸಮ್ ಲೀಗಲ್ ಪೊಸಿಷನ್ ಏನೋ ನೋಡಿ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರ. And one of the witnesses say, ಇವ್ರು ಹೇಳ್ತಾರೆ ಬಾರ್ನಿಂದ ಅಲ್ಲಿ ಹೋದಿ ಅಂತ. ಅಲ್ಲೇ PW2 ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಹೇಳ್ತಾರೆ ಕುಡಿದ್ರೆ ನಾನ್ ವೆಜಿಟೇರಿಯನ್ ಫುಡ್ ತಿಂದ್ರೆ ಆ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗೋ ಹಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿ. He has given he was stated so, PW2.
The officer I believe
electricity.
I'm assuming we have to assume with the right
that was functioning and working and that's all. You wanted to say something? No, according to them, TI parade is not conducted at all. Identification in the police station. No, in this case, no TI parade was held even in the police station. According to them, police showed them. No, the judgment which you have cited, it appears last time we said they are not applicable because those judgments relate to the regularity or validity of the TI parade. In this case, no TI parade conducted. So why are you citing those judgments ಅಂತ ಕೇಳಿದ್ವಿ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಹೌದಾ? ಇವ್ರು ಯಾರೋ ಇದ್ರು. You were not there, it seems. We asked identification in the police station at the instance of the police is not better evidence anta aa judgment ide nodi, because whatever judgment you have cited, they were about the validity or acceptability of the TI parade anta helidvi ನಾವು. ಹಾಗೆ ಹೇಳಿದ್ವಲ್ಲ last time. They have given host of judgments.
Having bearing of family, it has bearing. And it also depends on the bear.
Guidelines. Page number. ಎಷ್ಟು?
Page 22. If identification in the PIC and special And accordingly, if the evidence of CHP is not present.
Again.
Even identification in a court during trial is giving them. Even lately affected in the presence of court of the tribunal. Lack of preference is the two of the but if it has taken place, if something of identity in the police station has taken place, but the most of the police officer, including of the investigating officer,
Correct. That is, it is said that is inadmissible.
their lordship are you. Whatever you take the proceedings, short proceedings, and the move to making of a statement under the policy. Therefore, it is like
They have referred to some judgment. 20. Although that view is taken in this Chunturam versus state of Chhattisgarh and Ramkishan Mithanlal Sharma versus state of Bombay. Yes, 19 and 20. Yeah, the citation 19 and 20. One second, just wait. Even now, 1995 SC Finland 60 and Suresh Chandra. 19 and 20 ಅಂತ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ ಬೇರೆ ಇದೆ
Page 28.
Correct. Leonard Council in this para 32 ನಲ್ಲಿ ಪ್ರಪೋಸಿಷನ್ ಇದೆ ಅಲ್ಲ ಆ ಪ್ರಪೋಸಿಷನ್ ದೇ ರೆಫರ್ ಟು ದ ಅರ್ಲಿಯರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವ್ದದು ಚುಂತುರಾಮ್ ವರ್ಸಸ್ ಛತ್ತೀಸ್ಗಢ 19 ಅಂತ ಹೇಳಿದ್ದು ಇಲ್ಲಿ ಹೆಸರು ಬೇರೆ ಇದೆ ಮತ್ತೆ ಮಿಥನ್ಲಾಲ್ ಶರ್ಮಾ ಏನು ರಾಮಕೃಷ್ಣನ್ ಮಿಥನ್ಲಾಲ್ ಶರ್ಮಾ ಇಲ್ಲಿ ಕೊಟ್ಟಿರೋ ನಂಬರ್ಗೂ ಇಲ್ಲಿ ಕೊಡೋ ನಂಬರ್ಗೂ ವ್ಯತ್ಯಾಸ ಇದೆ
Today I am
yes. 2020 10 SCC 733. You are producing, yeah? ಅದೇ ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಿರೋದು
I know it.
ಅದು 1955 ರಾಮಕೃಷ್ಣ ಮಿಥನ್ ಲಾಲ್ ಸ್ಟಾರ್ಸ್
Yes, first picture, element para 10, page 5. Page 5, in page 5, page 10. Para 10.
yes
Is a relevant para is 11. The interpretation is the Congress perspective. Major class indications are here. Presence of the code is during when the identifications are held in code for that. A resultant communication platform of two statements made by identifiers to a police officer in course of identification or between the dance two.
so again they rely on that 1955 Supreme Court
This is immediately balance with the that may take a lot to balance.
yes
That's the conduct of IV center. How has emerged, how has been emerging in this case. Next, unnatural conduct of people. It is better or more to be meeting of trying to help the other purpose. I to the other person. Previously, he did not take any proactive step. The matter either report to the police or inform any of the family members. Such conduct of the allegation is responsible to nature. Then, remember, paragraph 16. Witness here, you witness, other witness are the paper in order, how the witness and get fact about the incident. Even before the attention to actually witness the reaction, not natural. How did the reaction at first? You the that you find specifically therefore the there must be expected the witnesses to view the disease as family members of the people. What would also be this involved them of the incident that we faced. Also, before we talk about the local police station, the comfort that they have said, then page 8, the second case law starts from page 8. Para 25 of this case law. Para 25 as from the page 14. In page 14. Para 25.
1980 to 60.
From the middle of the para 25. It further admits that the date of the accused was given to you by the court.
Paragraph 25. Where are you reading? Middle of that paragraph. Middle of the paragraph.
Page 14,
Yes.
25,
That is page 15, not page 14.
page 14,
No, there is some page, there is some error it seems. It is para 15. All right, we found it. Hmm.
He further admits that the names of the accused were given to him by the court. The same thing has happened in my other case. Names were given to him by the court. In these circumstances, therefore, if the appellant was known to him, is not known to him before the incident, the identified the first time in the absence of the test identification study, the failure of people to be not relied upon as by his court. This is also set up again. Moreover, the identification of the parties.
Correct. Here, in this case, these witnesses and the accused were not from the same place. ಇವ್ರದ್ದು ಎಲೆ ರಾಮಪುರ ಅನ್ನೋ ವಿಲೇಜ್ ಅಂತ ಹೇಳ್ತಾರೆ. Accused only they speak about their acquaintance with accused number 1. Accused number 1 ಆ ಬಾರ್ ನಲ್ಲೇನೋ ಹೊಡೆದ್ರು ಅಂತ. ಎಲ್ಲ ಬಾರ್ ಮೇಟ್ಸಕ್ಕೆ ಅನ್ಸುತ್ತೆ ಇವರೆಲ್ಲ. ಅಲ್ಲ ಅದರಲ್ಲಿ all these witnesses from ಎಲೆ ರಾಮಪುರ. Accused number 1 is from ತುಮಕೂರು. Accused number 2 is ಹರವೇಸಂದ್ರ ತುಮಕೂರು. Accused number 3 ಅವರೆಲ್ಲ 3 ಇದನ್ನೇ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ ಯಾವ ಸೋಮಶೇಖರ ಇಲ್ಲ ಸುನೀಲ ಸಿದ್ದರಾಜು ಸಿದ್ದರಾಮಯ್ಯ ಶಿವ they were from 3 to 5 were from ಎಲೆ ರಾಮಪುರ. 3 to 6 were from ಎಲೆ ರಾಮಪುರ. Kodalahodu. Rakesh, he is from Tumkur. 3 to 6 were from ಎಲೆ ರಾಮಪುರ. But 1, 2 and 7 were from other place. But in right, at least PW correct. At least PW2 had seen this first accused according to their statement in Tumkur they were acquainted and ಅನ್ಕೊಂಡ್ರು. With others they were not acquainted. ಎಲ್ಲೋ ಬೇರೆ ಊರವರು. At least these other witnesses PW2 ಬಿಟ್ರೆ 3 to 5 ಅವರೆಲ್ಲ they do not say that they were known to them earlier. 3 to 5 correct ಅದು. All it, why do you want to elaborate it further? Only this judgment ಏನೋ 1955 ಅಂತ ರೆಫರ್ ಮಾಡಿದಾರಲ್ಲ. It seems that is the first judgment on the point ಅದರಲ್ಲಿ. Once it amounts to statement under section 162 ಅಂತ ಹೇಳಿದಾರಲ್ಲ. ಅದನ್ನ ಕೇಳಿರ್ಲಿಲ್ಲ ನಾವು. We didn't ask him. We told our juniors, you were not there, it seems, no? You were not there. We said all the judgments which you have relied, they relate to the validity of the TI parade. In this case, no TI parade is conducted. Why do you want to cite those judgments? This in Chunturam's case, that has some relevance. But other things, that 1955 ಅಂತ ಹೇಳ್ತಾ ಇದ್ವಿ, you interrupted us. ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ it amounts to 162 statement ಅಂತ ಹೇಳಿ. ಎಲ್ಲ ಅಷ್ಟೆಲ್ಲ ಅವ್ರೇನೋ ಫಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೆ. AR 1955 SC 104 ಅದಾಗ್ಬೋದು ಅಥವಾ 10 AR 1955 SC 10 ಅನ್ಸೋಳೆ. ಆಮೇಲೆ ನೋಡೋಣ ಅಷ್ಟು ಡಿಕ್ಟೇಷನ್. There are two appeals. So 563 is by accused number 2. Accused number 1 and 3. And 604 is by ಇನ್ನೊಂದು appeal. Notes. By accused number 2. Challenging the judgment and order. Please take it. Judgment and order of conviction and sentence passed against them. Accused number 1 and 3 in SC number. Judgment and order of conviction cast against them in SC number 5031 of 2017 on the file of the 4th Additional District Institution Judge Madagiri. Accused number 1 and 3 have preferred criminal appeal number 563 of 2017 and accused number 2 has preferred criminal appeal number 604 of 2018. The appellants, along with accused number 4 to 7, were tried in SC number 5031 of 2017 for the charges. For the offences punishable under section 143, 147 ಮಾಡಿದ್ದಾರೆ, 148 ಮಾಡಿಲ್ಲ. ಒಟ್ಟಿಗೆ ಮಾಡ್ತಾರೆ 143, 147, 149. ಆಕ್ಚುಲಿ ನೈಫ್ ತಗೊಂಡಿದ್ರು ಅಂತಂದ್ರೆ 148 ಬರುತ್ತಲ್ಲ. For the offense is punishable under section 143, 147, 302, read section 149 IPC on the basis of the charge sheet filed by. ಯಾಕೆಂದ್ರೆ ಐವೋ ಅಷ್ಟಕ್ಕೆ ಹಾಕಿದ್ರು ಅವರು ಅಷ್ಟೇ ಚಾರ್ಜ್ ಮಾಡಿದ್ರು. Charge sheet filed by Kolala Police in crime number 34 of 2017 of their police station. For the purpose of convenience, the parties are referred to henceforth according to the ranks for the case. The case of the prosecution in brief is as follows. On case number 1 to 7 are all friends. On 1/4/2017, 8 to 8 p.m. ಇದು ಇರಕ್ಕಸಂದ್ರ ಕಾಲನಿ ಅಂದ್ರೂ ಯಲೆರಾಂಪುರದ್ದೇ ಒಂದು ಭಾಗನ ಆರ್ ಇಟ್ ಇಸ್ ಸಮ್ ಅದರ್ ಪ್ಲೇಸ್ ದಟ್ ಬಾರ್ ವಾಸ್ ಇನ್ ಇರಕ್ಸಂದ್ರ ಕಾಲನಿ ಅಂತ ಫಸ್ಟ್ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ಅದು ಇರಕ್ಕಸಂದ್ರ ಕಾಲನಿ ಅಂತ ಇದೆ. ಮಧುಗಿರಿ. ದಿಸ್ ಯಲೆರಾಂಪುರ ಇದೆಲ್ಲ ಒಂದೇ ಊರ? ಯಾವ ಟೌನ್ ಅಲ್ಲಿ, ಯಾವ ಸಿಟಿ, ಟೌನ್, ವಿಲೇಜ್? FIR ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. FIR ಇಸ್ ಎಕ್ಸಿಬಿಟ್ 352. ಯಲೆರಾಂಪುರ, ಕೊಳಾಲ ಹೋಬಳಿ, ಕೊರಟಗೆರೆ ತಾಲೂಕ್. ಇಟ್ ಅಪಿಯರ್ಸ್ ಯಲೆರಾಂಪುರ ಇಟ್ಸೆಲ್ಫ್ ಇಸ್ ಅ ವಿಲೇಜ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಮತ್ತೆ ಆ ಇರಕ್ಕಸಂದ್ರ ಅಂದ್ರೆ ಅಲ್ಲ, ಇದ್ರಲ್ಲೇನೆ ಈ ಊರಲ್ಲೇನೆ ಒಂದು ಕಾಲೋನಿನ ಇರ್ಲಿಕ್ಕಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಈ ಹಳ್ಳಿಗಳಲ್ಲಿ ಇರೋದಿಲ್ಲ, ಅದೆಲ್ಲೋ ಬೇರೆ ಪಕ್ಕ ಎಲ್ಲ ಹಳ್ಳಿಯಲ್ಲೂ ಬಂದಿದೆ ಬಿಡಿ ಈಗ. ಅದೇನೋ ಬೇರೆ ಕಡೆ ಇತ್ತು ಅಂತ ಕಾಣಿಸ್ತದೆ. ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ ಅಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ ಹೋಗೋದಕ್ಕೆ 3 hours ಬೇಕಾಗಿರುತ್ತಲ್ಲ. Correct. Whether they are any extension of any town or they are villages, what is that? Do you have any information? ವಿಲೇಜ್. ಆಮೇಲೆ ಇರಕ್ಸಂದ್ರ ಅಂತ ಇದೆಯಲ್ಲ, ಮೊದಲೇ ಇನ್ಸಿಡೆಂಟ್ ಆಗುತ್ತೆ ಯಾವ್ದ್ರಲ್ಲಿ? ಆ ಸ್ಕೆಚ್ ಆದ್ರೆ ಎರಡು ಅಲ್ಲೇ ಅದೇ ಸ್ಕೆಚ್ ಇಸ್ ಎಕ್ಸಿಬಿಟ್ P4. ಹೌದಿಲ್ಲ. ಇದು ಜಿಲ್ಲಾ ಮುಖ್ಯ ರಸ್ತೆ, ಆಂಜನೇಯ ಸ್ವಾಮಿ, ಚಂದ್ರಣ್ಣನವರ ಮನೆ, ಯಲೆರಾಂಪುರ, ಇರಕ್ಕಸಂದ್ರ ಕಾಲೋನಿ. ಆ ರೋಡಿನ ಆಚೆಗದು, ರೋಡಿನ ಈಚೆಗಿದೆ ಹೀಗಿದ್ದೆ ಅಂತ ಕಾಣಿಸ್ತದೆ. ಫ್ರೆಂಡ್ಸ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಇಲ್ಲ ಮೊದಲು ರಿಲೇಶನ್ಶಿಪ್ ಅದು ನೋಟ್ಸ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ. ನೋಟ್ನಲ್ಲಿ ಫೈಲ್ ಪ್ಲೇಸಸ್ ರಿಲೇಶನ್ಶಿಪ್ ಹೇಳಿದ್ದಾರೆ. ಬ್ರದರ್ CW1 ಗಂಗಾಧರ is elder brother. ಇನ್ನೊಬ್ರು ಬ್ರದರ್ ಇದ್ದಾರೆ. Friend of the deceased CW3-4 brother. CW1 and ಗಂಗಾಧರ, CW4 ಸೋಮಶೇಖರಯ್ಯ. Are the brothers. CW8 ಹೇಮಾವತಿ is a elder sister. ಇನ್ನೂ ಇದ್ದಾರೆ ಅಷ್ಟೊಂದು. ಒಬ್ರಿಗೊಬ್ರು ಮಗ ಆಗ್ತಾರಲ್ಲ. CW2 is he was the friend ಅಲ್ವಾ? CW2 is friend of CW1 ಅಲ್ಲ, deceased friend. Friend of deceased. ಇನ್ನೊಂದು ಹೆಸರು friend of the deceased ಹನುಮಂತರಾಜು ಅಲ್ಲ, ಸತ್ತಿರೋದನ್ನ ಹೆಸರು friend of deceased ಹನುಮಂತರಾಜು. PW correct. CW5 is the son of CW4. CW9 is the son of the nephew of the deceased. ಎಲ್ಲರೂ ಸಂಬಂಧಿಕರೇ ಇದ್ದಾರೆ. ಫ್ರೆಂಡ್ ಆಯ್ತಲ್ಲ, CW2 ಫ್ರೆಂಡ್ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಹೇಳೋದಕ್ಕೆ ಹೇಳಿದ್ರು. ಮತ್ತಿನ್ಯಾರಾದ್ರೂ ರಿಲೇಟಿವ್ಸ್ ಇದಾರ? ಇವರು PW14 is also related. ಫ್ರೆಂಡ್ಸ್ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ ಅಲ್ಲಿ PW15 PW4 ಅಲ್ಲಿ ಫ್ರೆಂಡ್ ಅಂತ ಹೇಳಿದಲ್ಲಿ PW14 ಅಂತಾನೆ ಬರ್ತದೆ. PW2 ಹೇಳಿದ್ದಲ್ಲ PW2 and 4 are the 14 are the friends of 36. PW15 is nephew, son of PW8. PW8 ಇದೆಲ್ಲ ಉಳಿದೋರ್ ಆಪ್ಷನ್. On on 1/4/2017 at 8 p.m. Accused number 1 had abused PW2 in foul language. Taking exception to that, deceased Hanumant Raju slapped accused number 1 to take revenge of the same on 1/4/2017 at 11:20 p.m. The accused, forming themselves into an unlawful assembly with a common object of committing murder of Hanumant Raju, armed with armed with knife, picked up quarrel with Hanumant Raju on the street near Maramma Temple in Elarampura. Further, accused number 1 and 3 to 7 gripped Hanumant Raju. Accused number 1 and 3 accused number 1 and 3 abated accused number 2 and 7 to stab Hanumant Raju. Accused number 2 stabbed Hanumant Raju with knife MO8 on his right shoulder and stomach. Committed his murder. Accused number 1 and 3 to 7 assisted accused number 2 in committing the murder. Accused number 1, I'm sorry, accused number PW1, I'm sorry, PW1 on the information ಯಾರು Manu Kumar is PW store. On the information, PW5 informed the incident to PW1 over phone. PW 2 to 4. Actually, PW4 is also ರೆಸ್ಟ್ ಆಮೇಲೆ ಬರ್ತಾರೆ ಅಂತ ಇದೆ. PW2 to 4 ಸಾಕ್ಷಿ 1 ಮತ್ತು 5 6ರವರು PW2 to 4 ಸರಿ PW2 to 4 witnessed the incident. And PW5 informed PW1 about the incident over phone. PW1 rushed to the spot. Then all of them shifted injured Hanumant Raju to Koratagere Government Hospital. After giving who is that doctor? Dr. Vijay Lakshmi, PW 17, the medical officer of Koratagere Government Hospital. After giving treatment, referred him to the major hospital. When Hanmant Roju was being shifted to Tumkur District Hospital, near the Doddegoda petrol bunk, he succumbed to the injuries. At 0030 p.m. Thereafter, PW 1 to 5 brought the victim back to Koratagere Hospital. PW 1 filed the complaint against the accused on on 2/4/2017 at 12:15 hours. Register ಮಾಡಿದವರು ಯಾರು PW? Based on the said complaint, PW 23 23 registered the FIR exhibit P32 against the accused P25. No, sorry, witness that FIR register ಮಾಡಿ PW 20. She has done a good compilation. You have done it? Good compilation. 25. And what he did, P23 investigation. Yes, sir. P23. And handed over the further investigation to PW 24. The CPI of PW register ಮಾಡಿದ್ವು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ 23 ಅವ್ರು ಇದನ್ನ ತಗೊಂಡಿದ್ದಾರೆ. PSI of Kolala police station registered FIR. He handed over the further investigation to PW 24. PW 24. Conducted the investigation. He only files the charge sheet. DYSP. He is the last witness. Conducted the investigation. During ಅದಕ್ಕೆ ಯಾರು DYSP ಅಂತ he files the charge sheet. PW 24 conducted the investigation. PW 24 during the investigation conducted the inquest measure. Spot measure also is spot inquest measure exhibit P9. Spot measure exhibit P2. User measures exhibit P20 and 21. Caesar measure seized the vehicles used by the accused. ಎರಡು DO vehicle ಅಲ್ಲ P20 freezer measure of a scooter. P335 property farm. P36 voluntary statement. Conductor engine.
Seized vehicle used by the accused.
Seized. Seized the arrested one. Arrested the accused. Seized the incriminating material under the hazards. Got conducted the same examination of on the dead body of the victim. Sent the seized articles to FSL Bangalore for chemical analysis. Recorded the statements of the witnesses. Got the sketch of scene of offense drawn, etc., and handed over the further investigation to PW 25. The DYSP of Madhugiri, PW 25 filed the FSL report. PW 25 collected the FSL reports. I think exhibit P18 is the doctor's opinion. Doctor's final. Collected the FSL reports and the opinion of the doctor and filed the charge sheet. Next. The trial court on hearing the parties, by hearing the parties, framed the charges against the accused. As aforesaid, for the offences punishable under section 143, 147, 302, and 149 IPC, the accused denied the charges. Therefore, the trial was conducted. To substantiate its case, the prosecution examined PW 1 to 26. What marked exhibit P1 to P46 and MO 1 to 9. The accused, after the examination under section 3 and 13 CRPC, did not read any defense evidence. The trial court, on hearing the parties, by the impugned judgment and the order, acquitted accused number 4 to 7, and convicted accused number 1 to 3 for the charge for the offense punishable under section 302, read with section 34 IPC. Further, the trial court for the said offense sentenced accused number 1 to 3 for life imprisonment and fine of rupees 10,000. And in default to pay the fine amount, to undergo simple imprisonment for 1 year. Accused number 1 to 3. State has not preferred any appeal. Challenging the acquittal of accused number 4 to 7, the state has not preferred any appeal. Whereas accused number 1 to 3 have preferred the above appeals. Questioning the judgment and order of their conviction and sentence. Admission of she has been partial, not senior counsel. ಯಾರಿಗೆ ಅಡ್ವೊಕೇಟ್ ಕರಿಯಪ್ಪನ or maintains 60 criminal film 564 and she Learned Council for the appellants in SC number 604 of 2018. Next one. There was ಬರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ವಿ ಅವ್ರು ಹೇಳೋದು ಎಲ್ಲಾನು ನೋಟ್ಸ್ ಇತ್ತಲ್ಲ ಇದು ಹೌದಾ ಅಕ್ಯುಮೆಂಟ್ಸ್. There is inordinate delay in filing the complaint which was not satisfactorily explained. PW 24, no, 24. The IO states that sorry, the evidence of PW 24 and PW 2 to 5 ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಲ್ವಾ, PW 2 to 5 the alleged eyewitnesses show that PW 34 correct 2 to 5 2 to 5. Even it is PW 1 also says he had gone there. Sorry, PW 1 to 5. PW 1 to 5 show that PW 34 on learning the incident visited Koratagiri Hospital at 12:30 hours during the intervening night of 1/4/2017. The witnesses state that they revealed the incident to him, but still he did not take any complaint. He did not record the statement of any of those witnesses. And allegedly directed PW 23 to register the FIR, register the complaint. But our complaint ಕೊಟ್ಟಿರೋದಿಲ್ವಲ್ಲ, ಹೇಗೆ ಹೇಳ್ತಾರೆ ಅವ್ರಿಗೆ? Correct, but he in his evidence said that ಅವ್ರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಕಂಪ್ಲೇಂಟ್ this man goes in the morning. Register the complaint. PW1 claims to have gone to the police station in the morning at
12:15.
I'm sorry, no, on 2/4/2015 at 12:15 p.m. 12:15 p.m. And filed the complaint, but the FIR exhibit P32 shows that the same was delivered to the magistrate at 5:15 p.m. 15 p.m. That goes to show that the FIR was registered belatedly on deliberations with the police and the complainant party, and PW 2 to 5 were planted as eyewitnesses. 2 to 5 also says he comes there and but our prakara ಅವರು eyewitness ಆಯ್ತು. 2 to 5 2 to 4 were planted as eyewitnesses, and PW 1 and 5 were planted as res gestae witnesses. Since PW 24 commenced the investigation, since police had by that time had already information of the incident, exhibit P1 P1 does not amount to first information, and that amounts to only a statement under section 162 CRPC, which is inadmissible. Even in that complaint, FIR, even in FIR, complaint ನಲ್ಲಿ ಹೆಸರು ಹೇಳೋದಿಲ್ಲ, FIR ನಲ್ಲಿ ಹೇಗೆ ಬಂತ ಹೆಸರು? ಕರೆಕ್ಟ್. In the complaint it appears ಇನ್ನಿಬ್ಬರು ಅಂತ ಬಂದಿದೆ ಅಲ್ವಾ? FIR ನಲ್ಲಿ one person, other one person, ಆಮೇಲೆ ಅದ 6 and 7 other one person ಅಂದಿದ್ದಾರೆ. Even in that complaint and FIR, the names of accused number 2 and 7 did not figure. Okay. How they were roped into the case was not explained. To the eyewitnesses, accused number 1, 2, and 7 were strangers. 1, 2, and 7 were strangers. ಅಲ್ಲ 1 was ಪುನೀತ್ ಅನ್ನೋನ್ಗೆ ಒಬ್ಬನಿಗೆ ಗೊತ್ತಿರ್ತಾರೆ. ಎರಡನೇ ನಾಗೇಶ್ ಅನ್ನೋನ್ಗೆ ಒಬ್ಬನಿಗೆ ಗೊತ್ತಿರ್ತಾರೆ. ಉಳಿದವ್ರಿಗೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿರೋದಿಲ್ಲ. ನಾಗೇಶ್ ಅಲೋನ್ ಸೇಸ್ ಅಬೌಟ್ ದಟ್ ಇನ್ಸಿಡೆಂಟ್. Okay. To the eyewitnesses. Okay. PW ಯಾರು 2 to 5 eyewitnesses ಅಂತವಲ್ಲ 2 PW1 and 3 to 5 accused number Punita is from Elerampura. Accused number 1 and 7. Accused number 1 and 7 were strangers to them. 2 is from Elerampura ಅಂತ ಇದೆ ಅಲ್ಲ. ಅಲ್ಲ FIR ನಲ್ಲಿ ಸರಿ FIR ನಲ್ಲಿರೋ ರ್ಯಾಂಕು ಇದ್ರಲ್ಲಿರೋ ರ್ಯಾಂಕು ಬೇರೆ. ಕರೆಕ್ಟ್. Sorry, we were misled by this FIR. Who is from Selur? 2 PW1 and 3 to 5, 1 and 3 to 7, and 3. Accused number 1, 2 and 7. 2 and 7 were the strangers. Even for accused number, I'm sorry, even for PW2, except for accused number 1, others were strangers. The evidence of PW1 to 5, evidence of PW1 to 5, no test identification parade was conducted for their identification by the eyewitnesses. According to PW1 to 5, they identified the accused. ಎಲ್ಲರನ್ನೂ ಅಲ್ಲೇ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. Accused in the police station at the instance of the police, which is inadmissible. Therefore, the further, though the IO was aware of PW 2 to 5 being the 2 to 4 being the eyewitnesses and the PW 5 being the Restatia witness, he did not record their statements during his visit to the scene of offense, and there was delay in recording their statements. That was not explained. ಏನೋ ಹೇಳ್ತಾರೆ ಅವರು, ಆರೋಪಿಗಳನ್ನ ಹಿಡಿಯಕ್ ಹೋಗ್ಬೇಕಾಗಿತ್ತು ಅದಕ್ಕೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಇದರಲ್ಲಿ. No, at one stretch he has said accused ನ ಹಿಡಿಬೇಕಾಗಿತ್ತು ಅದಕ್ಕೆ ನಾನು ಮಾಡಿಲ್ಲ ಅಂತ. ಮತ್ತೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಅದೇ ಹೇಳಿದ್ದಾರೆ, ಪೆಟ್ರೋಲಿಂಗ್ ಹೋದಾಗ ನನಗೆ ಇನ್ಫಾರ್ಮೇಶನ್. No, he doesn't go to the place of occurrence. He goes to the hospital.
In the hospital, he would ask 23
to resist. Correct, that's what we asked. ಇನ್ನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ. We have said, we have already recorded. ಇಲ್ಲಿ ಡಿಲೇ ಇಸ್ ನಾಟ್ ಎಕ್ಸ್ಪ್ಲೇನ್ಡ್ ಅಂತ ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು. IO ಏನ್ ಹೇಳಿದ್ದಾರೆ, please see the cross examination of this PW 24. He has said my priority was to arrest the accused ಅಂತ ಹೇಳಿ. That was not explained. The alleged recovery of knife ammo 8 was suspicious as suspicious ಅಷ್ಟೇ ಗೊತ್ತು. Suspicious. ಯಾವ್ದು ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ವಲ್ಲ, ಯಾವ ಮಹಸರಿಗೆ ಸಪೋರ್ಟ್ ಮಾಡಿರಿ? E20 is which mahasar that is? ಬೈಕ್ ಅದು ಏನು ಅಲ್ಲಿ ಏನು ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಇಲ್ಲ, ಬೈಕ್ ಸೀಸ್ ಮಾಡಿದ್ರು ಅದಕ್ಕೇನು ರೆಲೆವೆನ್ಸ್ ಏನು ಇಲ್ಲ, ಅದರಿಂದ ಏನು ಇದಕ್ಕೆ ಕನೆಕ್ಟ್ ಮಾಡಕ್ ಏನು ಇಲ್ವಲ್ಲ. ದ ಬೈಕ್ಸ್ ಅಲಿಜೆಡ್ಲಿ ಸೀಸ್ in no way connected the accused to the crime. Moreover, the witnesses to the said seizure did not support the prosecution version. The recoveries were the joint recoveries. The recoveries were the joint. Some witnesses say that PW ಇಬ್ರು ಹೇಳ್ತಾರೆ, 4 ಇನ್ನೊಬ್ರು 5-6 ಜನರು ಬಿಟ್ರೆ ಬೇರೆ ಯಾರು ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಬಹಳ ಜನ ಇದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ, 50-60 ಜನ. ಯಾರು ಹೇಳಿದ್ದಾರೆ? 2 to 4 ಹೇಳಿದ್ದಾರೆ. There were 50 to 60% ಅಂತ ಹೇಳಿದ್ರು. ಅದೇ ಸಮ್ ವಿಟ್ನೆಸಸ್ ಯಾರು PW ಅಥವಾ ಮನುಕುಮಾರ್ ಅನ್ನೋರು ಹೇಳ್ತಾರೆ, ದೇರ್ ವೇರ್ ಪೀಪಲ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಸಮ್ ಆಫ್ ದೆಮ್ ಸೇ ದಟ್ ಅಲ್ಲಿ PW4 ಆ ದೇವಸ್ಥಾನ ಪೂಜೆ ಮಾಡ್ತಿದ್ರು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವರು, ಈಸ್ ಅಂಕಲ್, ಈ ಸೇಸ್ ಯಾರು ಇರ್ಲಿಲ್ಲ, ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡು ಹೊರಟಿದ್ವಿ ನಾವು ಅಂತ ಹೇಳ್ತಾರೆ. As per the evidence of some of the witnesses, there were several people at the scene of offense. The evidence of the witnesses further show that the scene of offense was surrounded by residential houses. The IO did not examine any of the independent witnesses. PW1 to 5. 1 to 5. Then 1 to 5. Those who are cited as eyewitnesses and other circumstantial witnesses supporting the prosecution were all relatives or friends of the deceased, and they were interested witnesses. Their evidence was also full of material contradictions. The evidence on record goes to show that the whole investigation was a concoction to implicate victim to Mother Vedanta. So they interested witnesses on the evidence of PW, Dr. PW 17 shows that the persons who accompanied the injured did not give the details of the assault and the assailants. If PW1 to 5 were aware of the accused being the assailants and the manner of the assault, they should have revealed the same to PW17. The aforesaid facts and circumstances go to show that the whole investigation was concocted to implicate the accused in the case due to previous communal line ಮೇಲೆ ಅಂತ, due to enmity between the accused party and the complaint party. On the lines of communal differences. Therefore, sorry, the trial court. The trial court, without judicious appreciation of the evidence, facts and circumstances of the case, and the applicable law, convicts accused number 1 to 3, but based on the same evidence, acquits accused number 4 to 7. Accused number 1 and 3 stand on par with accused number 4 to 7. Though accused number 1 and 3 stand on par with accused number 4 to 7, that itself goes to show that the judgment of the trial court is self-contradictory and unsustainable. Therefore, the impinged judgment in order of conviction and sentence passed against accused number 1 to 3 are liable to be set aside. We don't sit that 19th Chandra in support of we have already said. Yes, evidence of 1941 with the process of identification by the identified. In support. Do you want us to refer to all your judgments? I think this 1955 is the continuation ಇವತ್ತು ಕೊಟ್ರಲ್ಲ so far as test identification parade. Test identification. There are too many compilations for us. Delay ಬಗ್ಗೆ ಯಾವುದು ಮಾಡಿದ್ದೀರಾ? Delay in FIR? ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರಾ? ಅವನು ಒಂದು ನೀವು ಒಂದೊಂದು ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಪ್ರಪೋಸಿಷನ್ ಏನಿದೆ ಅಂತ ಹಾಕ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಈಸಿ ಆಗುತ್ತೆ. ಟು ದ ಡಾಕ್ಟರ್ ಸರಿ ಅಲ್ಲ ಹೀಗೆ ಬರ್ತಾನೆ ಓದಿದ್ರು ಇನ್ ಸಪೋರ್ಟ್ ಆಫ್ ಈ ಸಬ್ಮಿಷನ್ ಶ್ರೀ ಹಶ್ಮತ್ ಪಾಷಾ ಲರ್ನಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ರಿಲೈಸ್ ಆನ್ ದ ಫಾಲೋಯಿಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್. ರಿಲೈಸ್ ಆನ್ ಅಂದ್ರೆ ಇವರಪ್ಪ ಅಂತ ಬರ್ತಾರೆ. Yes. Rahmat versus State of Haryana, 1996, 10 SCC 346. State of AP versus Sunati Ramulu, 1994, Supplement 1 SCC 590. Mehra Singh. This is about what? 1996 is about not giving the history before the doctor. Medical, but not disclosing the name of the assailant before the doctor, isn't it? Correct. ಒಂದೊಂದು ಸೆಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ನ ಒಂದೇ ಕಡೆ ಕೊಡೋಣ ಅಂತ ನೋಡ್ತಾ ಇದ್ವಿ. ಈಗ ಆಮೇಲೆ ರೆಫರ್ ಮಾಡಕ್ಕೂ ಈಸಿ ಆಗುತ್ತೆ. ಎರಡನೇದು ಸ್ಟೇಟ್ ಆಫ್ AP ವರ್ಸಸ್ ಪುನತಿ ರಾಮನ್. ಅದು ಕೂಡ ಅದೇ FIR ನಾಟ್ ರೆಕಾರ್ಡಿಂಗ್ ಇಟ್ ಅಮೌಂಟ್ಸ್ 162 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ. ದೆನ್ ಮೆಹರಾ ಸಿಂಗ್ interrogate L/NK versus State of UP, 1994 5 Supreme Court cases 188. ಇದೆಲ್ಲ ಡಿಲೇ ಇನ್ ಲಾಸಿಂಗ್ FIR ಅನ್ನೇ. Jainul Haq versus State of Bihar, year 1974, Supreme Court, page 45. 45. Is that how it is applicable? Unlawful assembly ಬಗ್ಗೆ. No meeting of that may be gathered from the conduct of the accused during the course of commission. Spur of movement. Even how this is applicable 1999 8 SCC. Sharing of common intention ಅದ್ರ ಬಗ್ಗೆ para 3 section 34 applicability of section 34 ಏನ್ ಬೇಡ ಅದು ಇಲ್ಲಿ 149 ಗೆ ಅವ್ರು ಮಾಡಿಲ್ಲ 34 ಇಲ್ಲಿ if they prove the presence of the eyewitnesses this section 34 comes otherwise why to load the judgment with many judgments not necessary ಬೇಕಾಗಿಲ್ಲ CH-03 counsel in support of his submissions relies on the following judgments. You want us to take today's judgments or previous judgments or both? Previous compilation, first citation. No? Nim compilation ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ಟಿದೆ ನಮಗುನು ಇರ್ಲಿ you have worked hard. ಅದು ಬೇಡದೇ ಇರೋದೆಲ್ಲ ತಕ್ಕೊಳ್ಳಿ ಒಂದು ಅಲ್ಲ ಇರ್ಲಿ we sought 1955 probably there seems to be because this is followed by that we say both of them but now we were interested to see what is that 1955 point of test identification parade test identification parade illa anta heladvalla illi this you also said this 1955 and ಇನ್ನೊಂದು 2000 upon point of arrest circumstances which make the fact of arrest improbable recovery of weapon it cannot be sole circumstances prove the guilt ಇದೆರಡು ತಗೊಳ್ಳೋಣ ಜೈಕಮ್ ಖಾನ್ versus state of UP 2021 13 SCC 716 Raja Naikar versus state of Chhattisgarh state central investigation this is about blood stains ಇವತ್ತು ಕೊಟ್ಟಿದ್ದು citation this is ಇವತ್ತು ಕೊಟ್ಟಿರೋದಲ್ಲ Chinturan versus state of Chhattisgarh out of TIP ಬಗ್ಗೆ ಇದರಲ್ಲಿ there were many out of this 2020 ನ 1955 ರೆಫರ್ ಆಗಿರೋದು Chinturan versus state of Chhattisgarh 2020 10 SCC 733 ಅದು TIP ಬಗ್ಗೆ 1982 ಯಾವ್ದು ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿರಿ ಅದು TIP ಅಂತ ಬರ್ದಿದ್ದೀರಿ ನೀವಲ್ಲಿ ಅದಕ್ಕೆ ಹೇಳೋದು 8 to 15 para 20 ಇಲ್ಲ this para 15 is it is not about Chinturan's case is about the conduct of the eyewitness not about TIP both ನಮಗೆ ರೆಲೆವೆಂಟ್ ಇರೋದು ಅದ್ರ ಬಗ್ಗೆ ಅದು ಇನ್ನೊಂದು 1955 ರೆಫರ್ ಮಾಡಿರೋದು ಸಬ್ಸಿಕ್ವೆಂಟ್ Mohanlal Gangaram Gehani versus State of Maharashtra. ಇಲ್ಲ page 15, para 25, page 15 ಅಂತ ಬರ್ಕೊಳ್ಳಿ. Were given to him by the police, not only tested. Police ಹೇಳಿದ್ರು ನಾನು. What it 1982 says? The same is 1982. ಇನ್ನೊಂದು then refer ಮಾಡಿದ್ದು this 1955 was relied on which case? ಎಲ್ಲ ನೋಡ್ತೀನಿ. As compilation first. We refer to that also, no? Already we have referred to that. ಇನ್ನೊಂದು AR 19. ಅದು 3 judges bench ಅದು AR 1955. ಇದು 2023 judges. Larger bench judgment is 19. Recent Nair versus State of Kerala. ಹೇಳಿದ್ವ ನಾವು ಅದನ್ನ 2023 1 SCC ಹೇಳಿರ್ಲಿಲ್ಲ ಅನ್ಸುತ್ತೆ, ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು. ಇರ್ಲಿ ಹಾಗಾದ್ರೆ ಬರ್ತದೆ. ಏನು ಗಿರೀಶನ್, ನಾಟ್ ಗ್ರೀಸನ್, ಗಿರೀಶನ್ ನಾಯರ್ ವರ್ಸಸ್ State of Kerala 2023 1 SCC 180. ಇದರಲ್ಲಿ ರಾಮಕೃಷ್ಣನ್ ಮಿಥುನ್ ಲಾಲ್ ಶರ್ಮಾ ವರ್ಸಸ್ State of Bombay ಅದಲ್ವಾ ಅದು 1955. ಹೌದು, ದಿಸ್ ಇಸ್ 2 judges. Ramakishan, Mithan Lal Sharma and others versus State of Bombay. Please take it. Here it appears in this case property identification was in question on the card. It says the process of identification by the identifying witness involves the statement by the identifying witnesses that the particular property is identified with the subject matter of the offense or the persons identified were concerned with the offense. This statement may be expressed or implied. The identifier may point out by his finger or touch the property, or the person identified may either nod his head or give his assent in answer to a question addressed to him in that behalf, or may make signs or gestures which are tantamount to saying that particular property identified was the subject matter of the offense or the person identified was concerned in the offense. All these statements expressed or implied, including the signs and gestures, would amount to a communication of the fact of identification by the identifier to another person. Such communication are tantamount to statements made by the identifier to the police officer in the course of investigation and come within the ban of section 162. The very process of identification, insofar as a police officer seeks to prove the fact of such identification, such evidence of his would attract the operation in section 162 and would be inadmissible in evidence. Only exception being evidence in regard to his mental act. ಅದಕ್ಕೆ ಮುಂದೊಂದು ಎಕ್ಸೆಪ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. The only exception being the evidence sought to be given by the identifier himself in regard to his mental act of identification, which he would be entitled to give by way of corroboration of his identification of the accused at the trial. ಮುಂದೆ ಹೇಳ್ತಾರೆ. They said identification statement made before the panchas is admissible, but before the police officer attracts 162. Make such a subtle distinction. Yeah. This. And Justice Venkata. Justice Bhagavati also. ಇದರಲ್ಲಿ ಬೇರೆ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕಂಪೇರಿಂಗ್ ಆದ್ರೂ ಬರೆದಿದ್ದಾರೆ. Correct. Justice Jagannath Das, though concurring, wrote another judgment. Supplement. Next. ಹೇಳಿದ್ನಲ್ಲ AR 1955 Supreme Court ಹೇಳಿದ್ರು. Ramakishan, Mithan Lal Sharma and others was AR 1955 Supreme Court 104. Submissions of she SPP 2 ಅವರಲ್ವಾ ಇದ್ರಲ್ಲಿ ಮಾಡಿದ್ದು she has done. Timothy Science Leonard History ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನಾವು ನೋಟ್ಸ್ ನೋಡ್ಬೇಕಾಯ್ತಾನೆ ನಾನು ಬರ್ಕೊಂಡಿದ್ದೆ. Merely because PW 1 to 5 ಮತ್ತೆ ಯಾರು ರಿಲೇಟಿವ್ಸ್ ಅಂತ ಇದ್ದದ್ದು 1 to 5 and merely because the witnesses are relatives are 1 to 5 8 ಯಾರ್ಯಾರು ಈಗ ಹೇಳಿದ್ರಲ್ಲ ಬರ್ಕೊಂಡ್ಬಿಡಂತ PW 1 to 5 ಇಲ್ಲಪ್ಪ 2 is not relative. 2 is not relative. 1 to 5, 8 and 15. 8 and 15 were the relatives slash friend. ಒಬ್ಬರೇ friend ಅದರಲ್ಲಿ ಇಬ್ರು friend of the deceased. They cannot be branded as interested witnesses. There is nothing to show that the implication of the accused was inuring any benefit to them. Therefore, they cannot be called as interested witnesses. The trial court rightly noticed that the incident was in wee hours. 3 hours. And after the festivity was over, therefore, independent witnesses not coming to the rescue of the victim, independent witnesses, so other localites not coming to the rescue of the victim, and victim is natural. When the others did not witness the incident, the question of recording their statements does not arise. PW6, the cashier of the bar supported the circumstance of motive, that is the quarrel between accused number 1 deceased and accused number 1 and the deceased on one hand, and involving PW2 and 3. 3 was not the eyewitness motive. 3 was not the eyewitness. PW2 ನಂಗೆ ತಿಳಿದು ಬಂತು ಅಂತ ಹೇಳ್ತಾರೆ. PW2 and 3 supported the case of the suspicion regarding motive circumstance. PW 2 to 4, the eyewitnesses to the incident were present and consistent regarding the vote acts of the accused and the occurrence of the incident. Their evidence was further corroborated by the statements given by them before the Judicial Magistrate under Section 164 of CRPC. They deposed that accused number 2 stabbed the victim and accused number 1 and 3 awaited accused number 2 to stab the victim. PW 15 and 16. The fact that the death was homicidal was not disputed. PW 15 and 16. The punches to the seizure of knife 08 under Exhibit P22, the Mahazar, supported the prosecution case. Why the accused first led to the police and punches to the scene of offense and then to the place where MO8 was concealed was within his special knowledge. That cannot be blown out of proportion. Since, as rightly observed by the trial court, the victim was met with a horrific death. The first concern of PW1 or his relatives will be to get the injured treated. In such heinous offences, the delay in registering the FIR, delay in filing the complaint, cannot be blown out of proportion. Moreover, PW1 has explained the delay, the grief being the cause for delay. That is acceptable. Due to the margin of error in the grasp of the human beings of the events and passage of time, some inconsistencies and contradictions are bound to happen while reproducing the facts of the case before the court. They are natural. There were no material contradictions in the evidence of PW 1 to 5. The core case of the prosecution was not demolished by such minor inconsistencies or contradictions. The seizure of the clothes of the deceased and the knife was proved. The FSR report with P45 shows that on both of them, the O with blood was found. That connects accused number 2. ಅದು accused number 2 ಅಷ್ಟೇ ತೋರಿಸಿದ್ದ, ನೈಫ್ ಅಲ್ಲ, ಜಾಯಿಂಟ್ ರಿಕವರಿ. Knife accused number 2 to the crime. That's all. The trial court on judicial appreciation of the evidence has convicted accused number 1 to 3. As their vote acts and participation in the crime was proved beyond reasonable doubt. The acquittal of accused number 4 to 7 does not any benefit to accused number 1 to 3. Thus, she seeks for dismissal of the appeal. ನೀವೇನಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ರಾ? ಇಲ್ಲ. Yes. On careful consideration of submissions of both sides and on examination of the material and record, the question that arises for consideration is whether the impugned judgment in order of conviction and sentence passed against appellants / accused number 1 to 3. I'm sorry, 1. Correct, 1 to 3, no? 1 to 3 is sustainable. Next one, analysis. As per the prosecution, the deceased slapping accused number 1 in Vijayabad claimed enmity in the mind of accused number 1, and that was the motive for the murder. Further, prosecution contends that to take revenge of that incident, accused number 1, 1 to 7, forming the unlawful assembly, came to L.A. Rampura village where festivities relating to the deities, ಅದರಲ್ಲೂ ಡಿಫರೆನ್ಸ್ ಇದೆ. 3 ದೇವತೆಗಳು ಯಾರು ಅಂದ್ರೆ ಒಂದು festivities in the which are those ಯಾವ್ದಾದ್ರು ನರಸಿಂಹ ಸ್ವಾಮಿ, ಮಾರಮ್ಮ ಟೆಂಪಲ್, ಆಂಜನೇಯ ಸ್ವಾಮಿ ಟೆಂಪಲ್, festivities of temples of ಮಾರಮ್ಮ, ಆಂಜನೇಯ ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಅವ್ರೇನೋ ನರಸಿಂಹ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ನರಸಿಂಹ ಸ್ವಾಮಿ. And at 11:20 p.m. accused number 1, 3 to 7 grappled Hanumantraju. Accused number 1 and 3 na abatement. 1 and 3 abated. Accused number 2, 1 and 3 abated. Accused number 2 to stab Hanumantraju, and accused number 2 stabbed Hanumantraju with knife MO8 and caused him fatal injuries. The incident was witnessed by PW 2 to 4. On learning PW 5 also, on hearing the commotion, PW 5 also came to the scene of offense, and he informed PW 1. Then PW 1 came to the spot. All of them. One more point we left ಹೇಳಿದ್ವಾಗ clothes of the eyewitnesses our arguments ಹೇಳುವಾಗ did we repeat say that ಹೇಳಿದೀವ? All of them shifted the injured to Koratagiri Hospital, where PW 17 attended to him and referred him to the higher hospital. When victim was being shifted to the higher hospital, he succumbed to the injuries on the way. And next, the case of the prosecution was based on The circumstance of number one, the circumstance of motive, the evidence of eyewitnesses, PW 2 to 4, recovery of knife MO8, another Mahazar is with P22. ಇನ್ನೊಂದು ಯಾವ್ದು ಕ್ಲೋತ್ಸ್ ಅಕ್ಯೂಸ್ಡ್ ಕ್ಲೋತ್ಸ್ ಸೀಸ್ ದ ಸೀಸರ್ ಆಫ್ ಬಟ್ ಇದೇನ ಸೀರಿಯಸ್ ಆಗಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ವಲ್ಲ ಕ್ಲೋತ್ಸ್ ಇಲ್ಲ ವೆಹಿಕಲ್ ದ ಸೀಸರ್ ಆಫ್ ದ ಕ್ಲೋತ್ಸ್ ಆಫ್ ದ ಡಿಸೀಸ್ ಅದು ಇನ್ಕ್ವೆಸ್ಟ್ ಅಲ್ಲಲ್ವಾ ಬ್ಲಡ್ ಸ್ಟೇನ್ ಕ್ಲೋತ್ಸ್ ಆಫ್ ದ ಡಿಸೀಸ್ ಅಂಡರ್ ದ ಮಹಜರ್ ಎಕ್ಸಿಬಿಟ್ P45 ಅಲ್ಲ P45 is FSL report. Inquest ಅಲ್ಲ P9 ಅದು inquest is ತಂದು ಆಯ್ತು ಅಲ್ಲ ಮಹಜರ್ ಎಷ್ಟು ಅಂತ ಅಷ್ಟೇ ಮಹಜರ್ ರಿಲೇಟೆಡ್ ನಿಮ್ಮ ಸ್ಟೇಟ್ ಇದ್ರಲ್ಲಿ ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ ಓಕೆ P9 ಅಲ್ಲ P9 ಇನ್ಕ್ವೆಸ್ಟ್ ಇಸ್ P9 ಆಯ್ತು ಈ ಸೀಸರ್ ಕ್ಲೋಸ್ ಸೀಸರ್ ಸ್ವಲ್ಪ ನೋಡ್ ಹೇಳಿ P9 ನೆಕ್ಸ್ಟ್ ದ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಅದೊಂದು ಹೇಳಿಲ್ಲ ನಾನು ಬೇಸ್ಡ್ ಆನ್ ಐ ವಿಟ್ನೆಸ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅಲ್ಲಿ ಅದಕ್ಕಿಂತ ಮೊದಲು ಎವಿಡೆನ್ಸ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ PW1 ಅದಾದ್ಮೇಲೆ ಐ ವಿಟ್ನೆಸ್ PW 2 to 4 ವೆಸ್ಟ್ ಏಷ್ಯಾ ವಿಟ್ನೆಸ್ PW 5 user of life ಅದೇನ್ ಸೀನ್ ಆಫ್ ಅಫೆನ್ಸ್ ವಾಸ್ ಆಲ್ರೆಡಿ ನೋನ್ ಅದು ಒಂದು ಮಜರ್ ಮಾಡಿದ್ದಾರೆ ಆಮೇಲೆ ಇದಾದ ಹೇಳಿದ್ಮೇಲೆ ಸೀಸರ್ ಆಫ್ ಕ್ಲೋತ್ಸ್ ಆಫ್ ದ ಡಿಸೀಸ್ ಮಜರ್ clothes of just please check that and next is medical evidence official witness. Next regarding nature of death to prove that the death was homicidal one, the prosecution relied on the evidence of PW paper book ಅಲ್ಲ ಕಳ್ಸಿದ್ದಲ್ಲ ದೇವರ್ ಸೀಸ್ ಅಂಡ್ ವಿಚ್ ಮಾರ್ಕೆಟ್ ಇನ್ಕ್ವೆಸ್ಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಾದ ಇನ್ಕ್ವೆಸ್ಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕನೋ ಅದು ಅಂತ ದೇವರ್ ಸೀಸ್ ಇನ್ಕ್ವೆಸ್ಟ್ ಟೈಮ್ ಸೀಸ್ ಮಾಡಿದ್ದಿರ್ಬೇಕಾದ ಆಫ್ಟರ್ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಬಟ್ ಅದಕ್ಕೆ ಯಾರನ್ನ ಎಕ್ಸಾಮ್ ಇವನ್ FIR ಕ್ಯಾರಿಯರ್ ಇಸ್ ನಾಟ್ ಎಕ್ಸಾಮ್ ಇಲ್ಲ ಅವ್ರು ಇವತ್ತು ಕೊಟ್ಟಿದ್ರಲ್ಲ ಇವತ್ತು ಈಗ ಇವ್ರು
guidelines
ಆಮೇಲೆ ಫೈನಲಿ once ಆಯ್ತು. ನಾಟ್ ವೆರಿ ಮೆಟೀರಿಯಲ್ ಒಂದು ಇವೆಂಟ್ಸ್ ಇದ್ರಲ್ಲಿ ಇರ್ಲಿ ಅಂತ ಈಗ ಹನುಮಂತ ಅವರೇ ಕೊಟ್ಟಿದ್ದ ಇದು ಸೈಟೇಷನ್ official witnesses regarding nature of death. The prosecution relied on the evidence of the 17 Dr. Vijay Lakshmi, medical officer of Karnataka General Hospital, and PW EM doctor. PW Dr. Nagabhushan. PW 11. PW 11 is the doctor who conducted postmortem examination on the dead body of victim Hanumantaraju and issued the postmortem report and his final opinion. PW 17. PW 17 deposed that on 2/4/2017 at 12 midnight, when she was working as a medical officer in Karnataka Government Hospital, Hanumantaraju was brought to the hospital with a history of Hammayanavarana Horekangu. I'm sorry, PW1 had brought victim Hanumantaraju with a history of stab injuries in a fight. She further deposed that the victim was gasping. She sutured the wound and referred him to Tumkur Hospital. Sutured the wound, gave him required preliminary treatment and referred him to Tumkur Hospital. And within half an hour, they came back. Stating that the victim was not breathing. On an examination, she found him dead. She further deposed that regarding her examination, she submitted the report exhibit P25, MLC intervention. Reports exhibit P25 and 26. In her cross-examination, she examining the victim was not disputed. Only certain corrections made by her in exhibit P25 were sought to be confronted to her, which she explained, saying that under confusion, she has corrected the mistakes occurred under confusion. Therefore, the victim being brought to the said hospital with a history of assault should prove PW doctor 11 PW 11 the medical officer of Karnataka Government Hospital reports that on 2/4/2017, on the requisition of the police in crime number 34 of 2017 of Kolala Police Station, he conducted the PM examination on the dead body of Hanumantraju between 5 p.m. and 7 p.m. And issued the PM report as per Exhibit P15. According to this witness, P15 is at page number. Got it. Delay. The evidence of W11 and Exhibit P15 shows that the following injuries were found on the dead body of the victim. Only page number 326 and 327 and following external injuries. First injury, second injury, and third one. ಅರ್ಧ ಇಂಗ್ಲಿಷ್ ಅರ್ಧ ಕನ್ನಡದಲ್ಲಿ ಪೆನ್ಸಿಲ್ ಇಂದ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ಅದನ್ನು P26. He further reports that on 22/4/2000, further reports that he had kept the final opinion regarding the cause of death pending, awaiting the FSL report, and on receipt of FSL report, to appoint that the death was due to final opinion is Exhibit P18. He issued his final opinion as per Exhibit P18, stating that the death was P18, stating that death was due to cardiopulmonary arrest secondary to hypovolumin shock due to stab injury to the right lung. He further reports that on the IO's requisition, he examined the weapon MO8 and issued the opinion as per Exhibit P16, stating that the injuries mentioned in the PM report could be caused by such weapon, and they will lead, and those injuries are likely to cause the death. Even in the cross-examination of this witness, nothing was elicited to discredit his evidence that the injuries were homicidal in nature and death was due to such injuries. The accused also did not seriously dispute the death being homicidal due to homicidal injuries, but their defense was that they were not connected to those injuries. or recovery of weapon MO8 at the instance of accused number 2. Therefore, the trial court was justified in holding that the death was homicidal one. Next, regarding the overlap, delay in resisting FIR and evidence of eyewitnesses regarding the eyewitnesses and the credibility of the manner of registration of FIR, the credibility of FIR. Yes. These 2 points overlap on each other. It is the vehement case of the prosecution that PW 2 to 4 were the eyewitnesses to the incident, whereas the accused contained that PW 1 to 5 were all planted. PW 2 to 5, 1 to 5 were all planted ಅಂತನಾ ಮತ್ತೆ ಅದರ ಅರ್ಥ planted as eyewitnesses, not planted ಅಂದ್ರೆ planted as 2 to 4 were planted as eyewitnesses. But PW1 ಅಲ್ಲಿ ಬಂದ್ರು ನೋಡಿದ್ರು ಕರ್ಕೊಂಡೋದ್ರು ಅದ್ರ ಬಗ್ಗೆ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲಲ್ಲ. That's what we said. According to you, they were planted as the eyewitnesses to connect the accused to the crime.
But because I am anxious for you, Mr. Bhavani, I request my lord to kindly have a complaint. And
we'll come to that exhibit P1. ಅದನ್ನ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ we'll discuss that. He says, I do not know who has written ಅಂತ ಹೇಳ್ತಾರೆ. PW1 ಯಾರು ಬರೆದ್ರು ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಇದನ್ನ ಅಂತ ಹೇಳ್ತಾರೆ. ಏನಾದ್ರು ಬೇಕಿದ್ರೆ ನಾವೇ ಕೇಳ್ತೀವಿ. ವಿಲ್ ಡಿಸ್ಕಸ್ ದಟ್. ಯಾಕೆ ಇವಾಗ ನಾವು ಹನುಮಂತರಾಯಪ್ಪ ಅವರು ಅವೇ ಬಿಕಮ್ ಹಾರ್ಡ್ ಆಫ್ ಹಿಯರಿಂಗ್ ನಾವು ಆಗುತ್ತೆ, ನಮಗೂ ಆಗುತ್ತೆ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿವಸಕ್ಕೆ. ಡೋಂಟ್ ವರಿ ಅಬೌಟ್. ಬಟ್ ಅದು ಕಡಿಮೆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾಗಲೂ ಯು ಹ್ಯಾವ್ ಟು ಗೆಟ್ ಅಡಾಪ್ಟೆಡ್ ಟು ಹಿಯರಿಂಗ್ ಏಡ್. ಅಂಡ್ ವಿ ಸಫರ್ಡ್ ಇಟ್ ವಿತ್ ಅವರ್ ಫಾದರ್ ಬಿಕಾಸ್ ಅಟ್ ದ ಅರ್ಲಿಯೆಸ್ಟ್ ಸ್ಟೇಜ್ ಮೈ ಫಾದರ್ ಡಿ ನಾಟ್ ಅಡಾಪ್ಟ್ ದಟ್. ಆಮೇಲೆ ಆಗೋದಿಲ್ವಂತೆ ಅದು. As eyewitnesses, PW1 and 5. And the prosecution, I'm sorry, the accused dispute the credibility of PW1 to 5, relatives 1 to 5,
8, 9.
ಅಲ್ಲೇ ಬರ್ತೀವಿ 1 to 5. Even according to the prosecution itself, PW1 and 5 were the here 1, 5, 8 and 15 ಅಲ್ಲ. 8, 9 and 15 were hearsay witnesses. Hearsay. The first challenge to the credibility of PW 1 to 5, 8, 15 and 8, 9 and 15 is that they are all interested witnesses. And the probable independent witnesses of the locality are not taken as they would not have supported the prosecution version about accused being the assailants. They further try to turn the credibility of the prosecution version on the ground of delay in filing the complaint / registering the FIR FIR and the conduct of PW 24, PW 24, the IO. Third is, and more other, and then the point. First one, interested witnesses. Second one, second in delay in filing the complaint. To ಮೂರನೇದು test identification part. Identification. Conduct ಹೇಳಿದಲ್ಲ, delay in filing the complaint ಆದ್ಮೇಲೆ conduct of PW 24, 4 identification of the accused. The accused. 5 contradictions in evidence of PW 1 to 5 and conduct of PW 24 ಆದ್ಮೇಲೆ ಅಲ್ಲೇ ತಗೊಂಡ್ವಿ. Not seizing clothes of PW 1 to 5. Next. It is no doubt to that PW. Is it no doubt to answer? The evidence of PW 1 to 5, 8, 9, 8, 9. 9. Nine is not interested. Huh? Government hospital nephew. But you nim idral bardilla adana, are you sure? PW 9 is the nephew, na? He is examined Koratagiri hospital ಹೋಗಿದ್ರು ಅಂತ ಹೇಳಿದ್ರು. Right. Innobರು 15. Illaru 15. PW 15. 15 is near Caesar of Navy. PW 16. He is the witness for scene of occurrence source. 15, 16. No? PW 8, 9, 15 and 16. 15 and 16. The evidence of the state witnesses themselves show that PW 1, 3 to 5, 8, 9, 8 and 9 were the close relatives of the deceased, and PW 2, 15 and 16 were the friends of the deceased. It is no doubt true that merely because of the relationship of the witnesses with the deceased, or they being friends of the deceased, their evidence cannot be discarded if the same is proved to be creditworthy. But that comes with a note of caution that the evidence of such they cannot be called as interested witnesses. They cannot be called as interested witness. But that proposition comes with a caution, note of caution that their evidence has to be cautiously analyzed. Similarly, the delay in filing in the heinous offenses like murder, the delay in filing the complaint, if explained satisfactorily, are found natural, does not demolish the case of the prosecution. The evidence of exhibit P1, the complaint. Exhibit P1 anta madam. The evidence of PW1 to 5 anta. The evidence of PW1 to 5 shows that soon after the incident, PW1 came to the scene of PW1 and 5 came to the scene of offense, and they shifted the injured to the hospital, Koratagiri hospital. ಡಾಕ್ಟರ್ ಎಷ್ಟೊತ್ತಿಗೆ ಬಂದಿದ್ರು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, PW 12:10 ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, PW 17 12:15 ಅಂತ ಹೇಳ್ತಾರೆ. Soon after the incident, the victim was taken to Koratagiri hospital. The evidence of PW 17 shows that the victim was brought to the hospital by PW1 with a history of assault. In the complaint, exhibit P1, PW1 has stated that he came to the scene of offense at about 11:40 p.m. on 1/4/2017. There, PW on the telephone, on the information of on the information by PW5 over phone, it is stated in exhibit P1 that while on that phone conversation itself, PW5 named Yuraru, Sunila, Siddharaju, except 2 and 7 bit ಉಳಿದವ್ರನ್ನೆಲ್ಲರನ್ನು ಹೇಳಿರ್ತಾರಂತ. named accused number 1 and 3 to 6 or 3 to 5 ಅಂದ್ರೆ ಹೆಸರುಗಳು 2 ಸಿದ್ದರಾಜು ಇದ್ದಾರೆ ಅಂತ ಕನ್ಸುತ್ತೆ. Correct, no? 3 to 6 as the assailants. He further says that when he came to the spot, 3 to 6 and two other persons. He further says that when he came to the spot, ನಾನು ಮನೋಕುಮಾರ ರಂಜಿತ್ ನಾಗೇಶ್ ರವರು ನಮ್ಮೂರಿನ ಆ ಸಮಯದಲ್ಲಿ ನಾಗೇಶ, ಪುನೀತ, ಸೋಮಶೇಖರಯ್ಯ, ಕಣ್ಣಾರೆ ನೋಡಿರ್ತಾರೆ. That no, sir. Says that the incident was witnessed by PW 2 to 2 to 4. 2 to 4. 2 to 4. Then himself PW 5. PW 2 5. ಈ ರಂಜಿತ್ ಅನ್ನೋರು CW ಎಷ್ಟವರು? Not examined. CW Ranjit, he charted witness. CW6 Ranjit. CW6 Ranjit shifted the injured to the hospital. Yes, that if exhibit P1 is to be believed, by the time PW1 came to the scene of offense, he was aware of accused number 1, 3 to 6 and 2 others being the assailants. But the evidence of PW17, no, but evidence, but PW17, the prosecution's own witness states that if that is the case, they should have revealed the names of the assailants before the doctor when victim was taken to Karnataka hospital. But PW17, the prosecution's own witness, states that PW1 gave the history only as stab injury due to assault, and he did not reveal other details. According to her, the victim was alive and was gasping. He had also not given any history. Exhibit P25 and 26 are the prosecution's own record. Idralli paper book nallilla MLC intimation. Exhibit P25. Paper book, one paper book. 26 is in paper book. In exhibit P25, the MLC register. The evidence of PW17 shows that the history given by PW2 was entered in MLC register, and exhibit P25 is the MLC register extract. That is also the prosecution's own document, which states that PW2 gave the history of assault, stab injury. The PW17 left the witness assailant, the space for assailant by putting by drawing a line. She has also recorded that detailed history was not known. Apparently, such entry is based on the information of PW1 himself. PW17 in her cross-examination deposes that when she inquired PW2 about the details of the fight, he told her that he doesn't know those details. He doesn't know the details. PW17 was an independent witness. There was no reason to disbelieve her evidence. If that has to be accepted, then the statement in Exhibit P1 that PW2 to 4 were the eyewitnesses and they revealed to him that the accused assaulted the victim with a knife becomes doubtful. Regarding the next paragraph, regarding filing of the complaint, the offense either under section 307 IPC or not to IPC was a cognizable offense. Any person who was aware of the incident could have set the law into motion. Section 154 of CRPC. In view of section 154 CRPC, any person aware of such offense would have set the law into motion. Exhibit P1 and P22, P32, sorry. Exhibit P1 complaint and exhibit P32. P32. Coupled with the evidence of PW1 and PW1, 24. ಇನ್ನೊಬ್ರು ಯಾರು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದವರು PW 24 and 23 will go reverse. Shows that when PW 24 was on patrol duty, he says 2 ಗಂಟೆಗೆ ಅಂತ ಹೇಳ್ತಾರೆ, but other witnesses say different thing. ಹಾಗೆ ಬೇಡ, ಹಾಗೆ ಅವ್ರದ್ದು ಬೇರೆ ಹೇಳ್ತಾರೆ, ಇವ್ರು ಬೇರೆ ಹೇಳ್ತಾರೆ. PW 24, okay. PW1 ಹೇಳಿಲ್ಲಲ್ಲ, correct. 24 and 23 shows that on 2/4/2017 at 2 a.m. when PW 24 was on patrol duty, he received information that Mangala Gaurama is also a charge sheet witness from ASI of their police station that about the incident and the dead body of victim being in the Koratagere hospital. PW 24 says that he visited the hospital and he inquired PW2, and PW2 told him about accused number 1, 3 to 6, 3 to 6 and others assaulting the victim. He also deposes that the dead body was in the mortuary and PW2 was accompanied by his relatives and friends. PW2 was accompanied. The relatives and friends of PW2 were also present in the mortuary. Despite that, he did not record the statement of any of those witnesses, any of those persons. When PW2 allegedly gave the history of gave the report of orally reported. PW2 orally reported the occurrence of a cognizable offense. It was mandatory for PW24 to record the same then and there only, and he could have sent such report to the police station, jurisdictional police station, which he did not do. As against that, he says that he informed PW23 about the incident, then went to LA Rampura to see the place of offense. Though PW23 says that PW21 presented the complaint before him on 2/4/2015 at 12:15 p.m. Exhibit P32 shows that 12:15 and he registered the FIR immediately. Exhibit P32, the FIR shows that the FIR was delivered to the jurisdictional magistrate at 5:15 p.m. Again, there was around 5 hours delay. 12 to 5:15 and 5 hours. I'm sorry, again, why it took 5 hours to deliver the FIR to the magistrate was not explained. The carrier of the FIR was not examined. An attempt was made referring to the last sentence in Exhibit P1 that to the effect that the delay occurred in filing the complaint as the complainant discussed with his elders. As rightly pointed out, though the entire complaint is typewritten or computerized in computerized script, the said the sentence alone is handwritten. PW1 says that he doesn't know who has written that. We'll have it on 1:35 Madhana special bench. Next week. Monday ಏನು ಸಿಟ್ಟಿಂಗ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ನನಗೇನು ಹೇಳಿಲ್ಲ ಅಷ್ಟಕ್ಕೆ ನಿಮಗೆ ನಾನು ಧಾರವಾಡಕ್ಕೆ ಸಿಟ್ಟಿಂಗ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ನನಗೆ ಹೋಗಿದ್ದಾರೆ ಮೊದಲು ಹೇಳಿದ್ರು ಆಮೇಲೆ ಹೇಳಿಲ್ಲ ಬೇಕಂದ್ರೆ ಹಾಕೊಳ್ತೀವಿ ಏನಾರು ಅಕಸ್ಮಾತ್ ಆಗಿ ಏನೇ ಅನ್ಸರ್ಟನಿಟೀಸ್ ಇದ್ರೆ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಡೇ ಹಾಕಿ ಮಾಡಿದ್ರು ಆಯ್ತು ಮಾಡಿ ಮುಂದಿನ ವಾರ ಒಂದು ವಾರದಲ್ಲೇ ಮುಗಿಸ್ತೀನಿ ಇದನ್ನ ಮಾಡಿದ್ದು ನಾನು ಬರ್ಕೊಡ್ತೀನಿ ಸೊ ದಟ್ ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ. Two of you have very meticulously argued, and Mr. Hanumantrayappa's juniors will have put in lot of efforts. But ನೀವು ತಯಾರು ಮಾಡ್ರಿ ಹಾಗೆ ಇವರನ್ನ ನಿಮ್ಮ ಜೂನಿಯರ್ಸ್ ಎಲ್ಲ ಯಾಕೆ ಮಾಡ್ತಾ ಇಲ್ಲ ನೀವೇ ಬರ್ಬೇಕು ಅಂತಾರೆ ಅವ್ರು ಕೋರ್ಟಿಗೆ ಬಂದು. ಯಾರ ಕರಿಯಪ್ಪ ಅನ್ನೋರ್ನ ನಾನು ನೋಡ್ತಿದ್ದು ತುಂಬಾ ದಿವಸ ಆಯ್ತು. ಮತ್ತೆ ಇನ್ಸ್ಟಿಲ್ ಸಮ್ ಕಾನ್ಫಿಡೆನ್ಸ್ ಇನ್ ದಮ್. ನಾವೇನು ಅಷ್ಟು ಟೆರರೈಸಿಂಗ್ ಇದೀವ? So dictated in part for further dictation list on Monday. These are the materials. Rest of the matters we'll repeat on the next working day. Monday bittilla Tuesday hakbidi. The other matters will be repeated to Tuesday. Shashidhar. ಇವತ್ತಿನವರೆಗೂ ಸೆಂಟೆನ್ಸ್ ಸಸ್ಪೆಂಡ್ ಆಗಿತ್ತಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 29. ಅದೇನು ಕರೆಕ್ಟ್ ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಕೇಸ್ ಪೋಕ್ಸೋ ಅಫೆನ್ಸ್ ಏನದನ್ನ ಮತ್ತೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋದ? ಅವ್ರ ಹಂಗೆ ಇನ್ಕ್ಯುಬೇಷನ್ ನಲ್ಲೇ ಬದುಕಿರ್ತಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಬರ್ತಾರೆ, ಸಿಗುತ್ತಾ ಫೈಲ್? ಕೇಸ್ ನಾಟ್ ರೀಚ್ಡ್ ಅಂತಾನೆ ಬರೀತಿ. ಕೇಸ್ ನಾಟ್ ರೀಚ್ಡ್. Interim order of suspension of sentence granted earlier is extended till next hearing date, subject to the same terms. List on reopening day 26. No, what is the order? Payable to Karnataka Legal Service. Board folder this order should require receiving execution of this order. Next steps. The detailed objects. ಕರೆಕ್ಟ್ ಇದ್ರಲ್ಲಿ ನಾವು ಮಾಡುವಂತದ್ದು ಏನು ಇಲ್ವೇ ಇಲ್ಲ. ನಮ್ಗೆ ರಿಜಿಸ್ಟ್ರಿ ಯಾಕೆ ಲಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಯಾಕಂದ್ರೆ ದೇ ಹ್ಯಾವ್ ಮೇಡ್ ಇಟ್ ಕ್ಲಿಯರ್ ದೇರ್ ಓನ್ಲಿ. ದೇ ಶಾಲ್ ಡೆಪಾಸಿಟ್ ವಿದಿನ್ 4 weeks. ಫೈಲಿಂಗ್ ವಿಚ್ KSLSA ಶಾಲ್ ರಿಕವರ್ ದ ಸೇಮ್ ಇನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳಿದೆ. ಮತ್ತೇನಿದೆ ಅದ್ರಲ್ಲಿ ಇನ್ನು ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ. ವೈ ರಿಜಿಸ್ಟ್ರಿ ಹ್ಯಾಸ್ ಲಿಸ್ಟೆಡ್ ದಿಸ್ ಮ್ಯಾಟರ್?
ಎಕ್ಸಿಬಿಷನ್ ಅಂತಾನೆ ಹೇಳಿದ್ವಿ.
Now we have made it clear.
We have to file an
See,
exhibition.
we have not filed any application for saying this. ಅಲ್ಲ ನಾವು 2 weeks ಕೊಡೋದೇ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ವಿ ಹ್ಯಾವ್ ನಥಿಂಗ್ ಟು ಡೂ. ವಿ ಹ್ಯಾವ್ ಪಾಸ್ಡ್. ಈಗ ನೀವೇನಾದ್ರೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಾವು 2 weeks ಟೈಮ್ ಕೊಡಿ ಅಂದ್ರೆ ದೇರ್ ಇಸ್ ಸಮ್ ಮೀನಿಂಗ್. ಯು ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್ ಎನಿ ಅಪ್ಲಿಕೇಶನ್ ಬಿಫೋರ್ ಅಸ್ ಅಂಡ್ ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ambiguous in this. They have to proceed.
ಅಷ್ಟೇ ಅಷ್ಟೇ.
Communicate the copy to the KSLSA ಅಂತ ಮಾಡಿಲ್ವ ನಾವು? ಏನು communicate copy of this order to the trial court and Karnataka Legal Service Authority forthwith ಅಂತ ಮಾಡಿದೀವಿ. We have nothing to do with this. ಏನಂತ
ಅವರು
KSA
ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ರೆ we have in the order itself they have said that if they fail to deposit they should proceed to execute the same ಅಂತ. ಫರ್ದರ್ ಮತ್ತೊಂದು ಆರ್ಡರ್ ಬೇಕಾಗಿಲ್ಲ ಅದಕ್ಕೆ. ಇಲ್ಲ ಲೆಟರ್ ಎಲ್ಲಿದೆ ಬರೀ ಅಲ್ಲ ದಿಸ್ ಇಸ್ ನಾಟ್ ಏನ್ ಕಂಟೆಂಪ್ಟ್ ಅದಲ್ಲ ಅವ್ರು ಕೊಟ್ಟರು. This is for our information ಅಷ್ಟೇ. We have to take it on record and for necessary action we have to take no action on our part. Action is on their part. There is the letter of the case member secretary of KSLSA. There is no action left on the part of the court.
KSLSA is at liberty to execute.
No, it has already said.
As stated in
the on imposing the cost by order dated by judgment dated 15/12/2023. This court has authorized KSLSA to recover the same in execution of the order if the same is not deposited, if the cost is not deposited within the stipulated time. No further action is left on the part of the court. The letter is taken on record. KSLSA is at liberty to execute and liberty to proceed in accordance with the order dated 15/12/2023. Correct. We have nothing to do in this matter. We have nothing left on our part. ನಾವೇನ್ ಕರೆಕ್ಷನ್ ಮಾಡಿ ಅವಾಗ್ಲೇ ಕೊಟ್ಟಿದೀವಿ. ಇದೇ ಆ ಕೇಸ್ ಅಲ್ವಾ? ಏನು one strip of land was there, acquired for land ಅಂತ ಹೇಳಿದ್ರು, ರೋಡ್ ಅಂತ ಹೇಳಿದ್ರು. But beyond that there was brothers amongst the brothers relatives. It is a successive well application. What is the name of this petitioner? Vishnu alias Manoj Kumar. Where is your the earlier order? You have produced it? You have not produced here. This SPP ಅಂತ ತೋರಿಸಿದಾರಲ್ಲ. Whether you are ready or not ready. But ಹೇಳ್ಬೇಕಲ್ಲ, he started argument, he is still not saying that. Yes, shall we have it in the next week? No, she says she is notified today only. You are local or? You are local. But yes, we'll next Friday special bench. Next Friday special bench. Thursday. Okay. Like also for that, the memo we file it with a memo. Like also for the petitioner submits memo with the copies of the orders in criminal petition number 381 of 2020 and 1677 of 2020. As requested by learned HCP, list on Thursday. Thursday. What about file has been not placed? Sure. Learned HCP accepts notice. Service sir ಮಾಡಿಲ್ವಾ ಕಾಪಿನ? ಇಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡ್ತಿದ್ರು ಸರ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ. As requested by learned HCP. Urgent next Thursday or urgent list on Thursday. Next Thursday. Friday will be ಇದು ಅಲ್ವಾ? Friday probably farewell ಇರುತ್ತೆ afternoon. Awaiting police report. ಯಾರೋ ಬಂದಾರಲ್ಲ? ಕರೆಕ್ಟ್ ಅವ್ರನ್ನ ಕೇಳಂತ ಹೇಳಿರಿ. ಕಂಪ್ಲೇನೆಂಟ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗಿತ್ತಲ್ವಾ? ಕರೆಕ್ಟ್ ಕೇಳೋಣ. ಏನಮ್ಮ ಏನ್ ಮಾಡ್ತೀರಾ? ಏನ್ ಕನ್ನಡ ಬರೋರ? ಕನ್ನಡದವರ ಇಲ್ಲಿ ಅವರು? ನಿಮ್ಗೆ ಏನಾದ್ರು ಹೇಳೋದಕ್ಕಿದೆ ಇದ್ರಲ್ಲಿ? ಹೇಳ್ಬೇಕಾ? ಅಲ್ಲ ನೋಡಿ, ಇದ್ರಲ್ಲಿ ಅವರು ಬೇಲ್ ಕೇಳಿದ್ದಾರೆ. ಶಿ ಇಸ್ ದ ಮದರ್ ಆಫ್ ದ ವಿಕ್ಟಿಮ್. ಮದರ್ ಆಫ್ ದ ವಿಕ್ಟಿಮ್. ಅಲ್ಲಿ ಅವ್ರಿಗೆ ನಿಮ್ ಕೇಸಿನ ಬಗ್ಗೆ ಗೊತ್ತು ತಾನೆ? ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಶಿಕ್ಷೆ ಆಗಿದ್ರ ಮೇಲೆ ಈಗ ಅವ್ರಿಗೆ ಬೇಲ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ನಿಮ್ಗೆ ಏನಾದ್ರು ಹೇಳಕ್ಕಿದೆಯಾ? ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ ನಿಮ್ಗೆ ಯಾರು ಲಾಯರ್ ಬೇಕು ಅಂದ್ರೆ ಕೊಡಿಸ್ತೀವಿ ಇಲ್ಲಿ. ಫ್ರೀ ಬೇಕು ಅಂದ್ರೆ ಫ್ರೀ ಕೊಡಿಸ್ತೀವಿ. ಶಿ ಸ್ಪೀಡ್ ಎಷ್ಟು ಹೆಸರು ಇರ್ಲಿಲ್ಲ. PW2. PW2. I mean, slash respond number. Respond number to slash PW. Respond number to respond number to slash PW2 appears along with escorted by WPC number ಏನದು or WPC or WHC number so and so escorted by Srimati so and so WHC number so and so respond number to seeks free legal aid. Therefore, the matter is referred to High Court Legal Services Committee to render free legal aid to respond number 2. List on ಇದು ಒಂದು 10 days ಬಿಟ್ಟು ಯಾಕಂದ್ರೆ ಅವ್ರಲ್ಲಿ ಹೋಗಿ ಬರ್ಬೇಕಲ್ಲ. It will not be possible. 1st March. ಆಗೋದಿಲ್ಲ ಅವ್ರಿಗೆ ಹೋಗಿ ಅಲ್ಲೆಲ್ಲ ಪ್ರೊಸೀಜರ್ ಆಗ್ಬೇಕಲ್ಲ. ಅಲ್ಲ ಅವ್ರು ಹೈಕೋರ್ಟ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಕಮಿಟಿ ಇರ್ತದೆ. ನಾಗರಾಜ್ ರೆಡ್ಡಿ ಇದರಲ್ಲಿ ಕೂಡ ಅವ್ರಿಗೆ ನಾವು ಮತ್ತು ಅಮಿಕಲ್ ಯಾಕಂದ್ರೆ ಒಂದೊಂದು ಪ್ರೊಸೀಜರ್ ಇರುತ್ತೆ. ನಾವು ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಇವ್ರಿಗೆ ಕೊಡಿ ಅನ್ನಕ್ಕಾಗಲ್ಲ. ಆರ್ ವಿ ಕ್ಯಾನ್ ಅಪಾಯಿಂಟ್ ಹಿಮ್ ಆಸ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿ. ಆದ್ರೆ ಅವರೇ ಕೊಡ್ತಾರೆ, ಯಾರಿಗೂ ಅಸೈನ್ ಮಾಡ್ತಾರೆ. ಅವ್ರು ನೋಟಿಫೈ ಮಾಡಿದ್ಮೇಲೆ ನೀವು ಕೇಳ್ಕೊಂಡ್ ಕೊಡಿ. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಇವ್ರಿಗೊಂದು ಪವರ್ ಇರುತ್ತೆ, ಅಲ್ಲಿ ಚೇರ್ಮನ್ ಇದ್ದವ್ರಿಗೆ. ನಾವು ಅದನ್ನ ಜುಡಿಷಿಯಲ್ ಸೈಡ್ ಕೊಡಬೇಕು. ಡೇಟ್ ಕೊಡ್ತೀವಿ. 1-3 ಇರ್ಲಿ ಬಿಡಿ. 1-3 ನೀವು ಅವ್ರಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿಯಲ್ಲಿ ಅವ್ರು ಇರ್ತಾರೆ. ಅವ್ರ ಹತ್ರ ವಕಾಲತ್ತು ಸಹಿ ಮಾಡಿಸ್ಕೊಟ್ಟು ಹೋಗಿರ್ತಾರೆ. Petitioners Council ಸರಿ ಇದು ಅದಕ್ಕಿಂತ ಮೊದಲು ಬಿಗಿನಿಂಗ್ registry has placed the report of the police inspector of Monday West Police Station to the effect that respond number 2 is served. ಅದಾದ್ಮೇಲೆ ಮುಂದಿನ ಬರ್ತದೆ. ಲಿಸ್ಟ್ ಆನ್ 1-3 ಅವ್ರು ಕರ್ಕೊಂಡು ಹೋಗಿ ಅವ್ರಿಗೆ ಯಾರಿಗಾರ ಹೇಳ್ಸಿ ಗೊತ್ತಿದೆ ನಿಮ್ಗೆ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಹೈಕೋರ್ಟ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಕೇಳ್ಕೊಂಡು ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಅವರು ಕೊಡ್ತಾರೆ. No representation for the petitioner, so petitioner is in judicial. Therefore, matter is reported High Court Legal Services Committee for providing free legal aid to the petitioner. Now you are free legal aid counsel. If already bail was granted, then why have filed it? How long he was absent? 2023 ವರೆಗೂ ಹೋಗಿಲ್ಲ. No, see, he is A1 alva, accused number 1. No, a case against him was split up. He didn't appear. 2020 ಇಂದ ಕೋವಿಡ್ ಶುರುವಾಗಿರೋದು. ಕೋವಿಡ್ ಮುಗಿದ ಮೇಲೆ ಅರೆ case was not against the lawyer, case was against this accused. He should be worried about his case. Page 26. 26. Yes, yes. Correct. We wanted to see ಇವಾಗ 2021 ಇಂದ A1 absent. Issue NW split up again as per the order passed in SC number 163 of 2018 dated 4/2/2021. A separate split up case against accused number 1 Krishnamurthy is registered as there is no likelihood of securing his presence in the near future. So 2021 in the how long he was absent? 11/1/2023 he was not secured. Page 16. Yes. Innocent, etc.
That's actually it. This is a medical issue, not entirely but development. Now you undertake so there is more about regularly. This is the.
No, this kind of undertaking. Yes, what do you say? Now, what is the stage of the trial?
Now you looking at the stage of the.
We don't. See, just take what is the position in the trial court? 37. No, 37 ಅಲ್ಲಿ ಇದು 26/11/12/2022 ಈಗ ಟ್ರಯಲ್ ಮುಗಿತಾ ಬಂದಿದ್ರೆ ಅವಾಗ ಇನ್ನೂ ಇಶ್ಯೂ NBW ಅಂತಾನೆ ಆಗಿತ್ತು. ಅಲ್ಲ ನೀವೇ ಬಂದಿಲ್ಲ, ವಿಟ್ನೆಸ್ ಬರೋದು ಹೇಗೆ? ವಿಟ್ನೆಸ್ ಬಂದೇನ್ ಪ್ರಯೋಜನ? ಇದು 25/10 to which accused number 2 is not produced from JC through VC. Again case is called at 3 PM. A2 is not produced. ನಿಮ್ಮ ಸಲುವಾಗಿ ಒಬ್ರು ಅಷ್ಟು ವರ್ಷ JC ಯಲ್ಲಿದ್ದಾರೆ. accused number 2 intimate. ಅಲ್ಲ ಆ ಕೇಸ್ ಬೇರೆ ಈ ಕೇಸ್ ಬೇರೆ. ನೀವು ಕೊಟ್ಟಿರೋದು 160. ನಾನು ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋ ಪ್ರಕಾರ ಈಗ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಕೇಸ್ 22/2021. Now the case is being tried against him. He is tried in SC 22/2021. You are showing us the order sheet of 163/2018. So that's the one. 2020. What is the latest position? ಇನ್ನು ಮತ್ತೆ 14/3/2023 ಅಷ್ಟರವರೆಗೆ ಮಾತ್ರ ಇದೆ ಇದು. 11 ಇಶ್ಯೂ NBW ಮತ್ತೆ ಇಲ್ಲ NBW ಆಗಿದೆ ಅಲ್ಲ, ಹಾಗೆ ಸ್ಟೇ 11 ಅವ್ರು ಸಿಗದೆ ಕೇಸ್ ಈಗ ನಡೆಯುತ್ತೆ. A1 ಪ್ರೊಕ್ಲಮೇಶನ್ ಎಲ್ಲ ಆಗಿದೆ. ಏನು ಯಾಕಂದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತಂದು ಯಾರ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಪ್ರೊಕ್ಲೇಮ್ಡ್ ಅಫೆಂಡರ್ಗೆ ಬೇಲ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. So whether he is the same advocate who was appearing before the trial court. ಕರೆಕ್ಟ್. ನಾವ್ ಏನ್ ಕೇಳ್ತಿದ್ವಿ ಅಂದ್ರೆ, ಈಗ ನೀವ್ ಹೇಳಿದ್ರಿ ಮ್ಯಾಟರ್ ವಾಸ್ ಡಿಲೇಡ್ ಅಂತ ಹೇಳಿ, ಬಟ್ ಡಿಲೇ ಇಸ್ ಬಿಕಾಸ್ ಆಫ್ ಹಿಸ್ ಅಪಿಯರೆನ್ಸ್ ಓನ್ಲಿ. ಅಂಡರ್ಟೇಕಿಂಗ್ ಹೌ ಟು ಅಕ್ಸೆಪ್ಟ್. ವಾಟ್ ಇಸ್ ಏನಾರ ಹೆವಿ ಫೈನ್ ಹಾಕಿ ಮಾಡ್ಬೋದಾ? ಬಟ್ ಏನ್ ವಾಟ್ ಇಸ್ ಹಿಸ್ ಅಕ್ಯುಪೇಶನ್? ಕೂಲಿ. ಅದೆಲ್ಲ ಫೈನ್ ಹಾಕ್ತಿವಿ ಅಂದ ತಕ್ಷಣ ಕೂಲಿಗಳಾಗ್ತಾರೆ. ಹಂಗಂದ್ರೆ No, we will impose some conditions. They should have the pinch of it. For more than 2-3 years, he was not accessible to the court, and now he wants to blame his advocate. He didn't contact me anta. ಅವ್ರಿಗೆ ಯಾಕೆ ಪಾಪ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾಕೆ ಪ್ರೆಷರೈಸ್ ಮಾಡ್ಬೇಕು? ಏನ್ ಸಲುವಾಗಿ? ಹರ್ಡ್ ಬೋಸ್ ಮೊದ್ಲಿನ ಬೇಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಬೇರೆ ಪಿಕ್ಚರ್. The appellant, petitioner, ಎರಡು ಮೂರು ಮಾಡಿ is seeking bail in SC number 22/2021 pending on the file of the principal district and session judge, Bangalore rural district. This court proclaimed offender anticipatable. The appellant is accused number 1 ಅಲ್ಲ. Appellant was accused number 1 in SC number, ಅದು ಬೇರೆ ಇದೆ. SC number 163 ಎಷ್ಟದು? 163/2018. he was being tried in the same case along with ಯಾರದು ಬೇರೆ accused ಎಷ್ಟು ಜನ ಇದ್ರಲ್ಲಿ there were only petitioners assaulted petitioners ಅಂತ ಇದೆ ಇಬ್ರು ಕೃಷ್ಣಮೂರ್ತಿಗಳೇ ಒಬ್ರು ತಿಮ್ಮಯ್ಯ ಇನ್ನೊಬ್ರು ಕರಿಯಪ್ಪ ತಿಮ್ಮಯ್ಯ ಇವರೆಲ್ಲ ಮೂರ್ಖ ಕಡೆಯವರು appellant petition accused number 2 who was another Krishnamurti for the charges for the offences punishable under section 302 and 201 ಅಲ್ಲ yeah 2 and 201 IPC on the allegation that the accused that on 21/4/2017 between 9 and 10 p.m. the accused assaulted one victim Sayed Khalil near Mallara Banawadi cross. Assaulted anta mela petition accused committed murder of one Sayed Khalil near Mallara Banawadi cross and robbed him of his 5,570 and his mobile phone. This court, by order dated 20/12/2018, had granted him a bail on the ground that by order dated case number 20/12/2018 in criminal petition number 7169 of 2018 had granted him bail on the ground that the case is based on circumstantial evidence, etc. After granting bail, he jumped the bail condition and fled away. The trial court was fled from the court till ಯಾವಾಗ ಅರೆಸ್ಟ್ ಮಾಡಿರೋದು ಈಗ ತಿರುಗಿ ಇಲ್ಲೆಲ್ಲ ಓದಿದ್ವಲ್ಲ he is produced ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನೋ NBW ಅಂತ ಸಿಕ್ತಾ ಈ ಇಶ್ಯೂ NBW ಅಂತ ಇದರಲ್ಲಿದೆ ಸ್ಪ್ಲಿಟ್ ಆಫ್ ಇದಿಲ್ಲ ಸ್ಪ್ಲಿಟ್ ಆಫ್ ಅಂತ ಇದೆ ಇದರಲ್ಲಿ 2021 ಯಾವತ್ತು ಅರೆಸ್ಟ್ ಆಗಿ ಯಾವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಕೋರ್ಟ್ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಆಗಿರೋದು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳ್ಕೊಂಡಿದ್ದೀರಾ ಅದರಲ್ಲಿ ನೀವೇನ ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಕೊಟ್ಟಿದಾರ ಮತ್ತೆ ನೀವು ಇಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿ ಬರೋದಿಲ್ಲ ಯಾರು ನೀವು ಕೃಷ್ಣೇಗೌಡ ಅಂದ್ರೆ ನೀವೇನ ಮತ್ತೆ ವಕಾಲತ್ ಹಾಕಿ ಇದೆಂತದ್ರಿ ಒಂದೇ ಸರಿ ನಾವ್ ಮಾಡಿರ್ಲಿಕ್ಕಿಲ್ಲ ಇದನ್ನ ಒಂದೇ ಸರಿ ಅಬ್ಸೆಂಟ್ ಎರಡ್ ಸರಿ ಸಕ್ಸಸ್ಫುಲಿ ಯು ಡಿಡ್ಂಟ್ ಅಪಿಯರ್ ವಾಟ್ ಇಸ್ ದಿಸ್ ಇಲ್ಲಿ ಇಷ್ಟೊಂದು ಜನ ಅಡ್ವೊಕೇಟ್ಸ್ ಇರ್ತಾರೆ ಅಟ್ಲೀಸ್ಟ್ ನಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೂ HCJP ಯಾರಿಗೋ ನಮ್ಗೆ ಬರಕ್ಕಾಗಿಲ್ಲ ಒಂದು ಪಾಸ್ ಓವರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಕೊಡ್ತಾರೆ ಎಲ್ಲ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಇದೆ ಅಲ್ಲ ಪರ್ಸನಲ್ ಡಿಫಿಕಲ್ಟಿ ಇದ್ರೆ ವೈ ಡು ಎಕ್ಸೆಪ್ಟ್ ದ ಬ್ರೀಫ್ಸ್ ಎಲ್ಲಿ ಸಿಕ್ತಿಲ್ಲ ಬಿಚ್ಚು 2023 ವರೆಗೂ ಸಿಕ್ಕಿಲ್ಲ ಅವ್ರಿಗೆ ಲಾಸ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಇರೋದು 11/9/2000 ಪಿಟಿಷನ್ ಅಲ್ಲೂ ಹೇಳ್ಕೊಂಡಿಲ್ಲ ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ಪಿಟಿಷನ್ ಇಸ್ ದಿಸ್ ಹೇಳ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲ ಫೈಂಡಿಂಗ್ ಅಲ್ಲಿ ನೋಡಿದ್ವಿ ನಮ್ಗೆ ಕಾಣ್ಲಿಲ್ಲ ಅದು ಡೇಟ್ ಎಲ್ಲೂ ಕಾಣ್ಲಿಲ್ವಲ್ಲ ನಮಗೆ ಅಲ್ಲ ಎಲ್ಲಿವರೆಗೂ ಅಪ್ಸ್ಕೊಂಡಿದ್ರಂತ ಎಷ್ಟು ದಿವಸ ಇದ್ರು ಅಂತಾರ ಹೇಳಿದಾರ ಪ್ಯಾರಾ 9 ನಲ್ಲಿ ಫಾರ್ ಹೌ ಮೆನಿ ಇಯರ್ಸ್ ಕುಡಂಟ್ ಬಿ ಸೆಕ್ಯೂರ್ಡ್ ಅಂತ Till the end of 2023. ಯಾಕಂದ್ರೆ one thing we can infer that 11/9/2023 ಗೆ ಅವನಿಗೆ ಪ್ರೊಕ್ಲಮೇಶನ್ ಆಗಿದೆ. ಪ್ರೊಕ್ಲಮೇಶನ್ ಗೆ 30 days ಕೊಡ್ತಾರೆ, 60 days ಕೊಡ್ತಾರೆ, 30 days ಕೊಡ್ತಾರೆ. ಸೊ 11/10/2023 ಅವ್ರಿಗೆಲ್ಲ ಸಿಕ್ಕಿರೋದಿಲ್ಲ till the end of 2023. ಎಷ್ಟು ವರ್ಷ? 2018 ಇಂದ 23 ಅದೇ for about more than 4 years. 4 years. We don't find really telling, we don't find any ground. ಈ ತರ 4 ವರ್ಷ ಪತ್ತೆ ಇರ್ಲಾರ್ದವ್ರಿಗೆ ಏನ್ ಕೊಡೋದು? We are not allowed. Now we'll make it another point ಅಷ್ಟೇನೆ. The conduct of the appellant, conduct of the appellant is deprecable. However, having regard to the fact that even before this court, his counsel, the counsel engaged by him, did not appear and do the needful, and to give one more opportunity, and as the case is based on circumstantial evidence, to give one more opportunity, the petition, give one more opportunity. Petition can be allowed by imposing stringent conditions. Hence the following order. The petition is allowed. The appellant, I'm sorry, petitioner. ನಾವೀಗ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ, ಹಾಗಾಗಿ ಅಪೆಲೆಂಟ್ ಅಂತಾನೆ ಬರುತ್ತೆ. Petitioner is granted bail in SC number 22 of 2021 pending on the file of the Principal District and Session Judge, Bangalore Rural District, subject to the following condition. We shall deposit the fine of rupees 10,000. 10,000 ಹಾಕಲ್ವಾ, ಇನ್ನೊಟ್ಟು ಹೆಚ್ಚಿಗೆ ಹಾಕೋಣ. 10,000 before the trial court. He shall execute personal bond in a sum of rupees 1 lakh and furnish one surety, one ಹಾಕಲ್ಲ, ಎರಡು ಹಾಕಲ್ಲ, surety, 2 sureties in the like sum to the satisfaction of the trial court. He shall appear before the court as and when required. If he fails to comply any of these conditions, this order shall stand revoked. Communicate the copy of this. Why should we pressurize the trial court? ಅಲ್ಲಿ ಹೋಗಿ ಕೇಳ್ಕೊಳ್ಳಿ, ನೀವು ಅಪಿಯರ್ ಆಗಿ ಆಮೇಲೆ ಎಕ್ಸ್ಪಿಡಿಷನ್ಸ್ಲಿ ಅಪಿಯರ್ ಆಗೋದು ಕೇಳಿ. Learned counsel, it is not for your career. ಈ ತರ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ, ನಿಮಗ್ ಒಳ್ಳೇದಲ್ಲ ಅದು. ಅಪಿಯರೆನ್ಸ್ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ಬೋದಲ್ಲ. ಇನ್ನು ಚಿಕ್ಕವ್ರು ಇದಾಗಿದ್ದೀರಿ, ಹೇಳಿ ನಿಮ್ ಬ್ರದರ್ಗೆ.
ಅಮಿತಾಶ್ ಆನಂದ್ ದೇಶಪಾಂಡೆ ಅವರ ಹೆಸರು.
ಇಲ್ಲ ಇವ್ರ ಹೆಸರೇ ತೋರಿಸಿ, HCLC ಅವ್ರು ತೋರಿಸಿ. ಇವ್ರು ಅದೇ ಕೇಸ ಅಲ್ಲ, ಅವ್ರನ್ನು ಬೇಲ್ ಜಂಪ್ ಮಾಡಿದವ್ರನ್ನ. ಆದ್ರೂ ಅಲ್ಲಿನೂ ಅಗೇನ್ ದ ಸೇಮ್ ಥಿಂಗ್ ಅಲ್ವಾ, ಇಬ್ಬರಿಗೂ ಅಂದ್ರೆ ಕಾಮನ್ ಆರ್ಡರ್ ಕೂಡ ಹ್ಯಾವ್ ಬಿನ್ ಪಾಸ್ಡ್ ಅಲ್ವಾ ಎರಡರಲ್ಲೂ. ಮೊದಲೇ ಯಾಕೆ ಹೇಳಿಲ್ಲ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕಲ್ಲ, 50 ಸ್ಟ್ಯಾಂಪ್ ಹಚ್ಚಿಲ್ವಾ? At request 1 week time is granted to complete office objections. Comply it. ಇಲ್ಲಿ ನಾವು ತಗೊಳ್ಳೋದಿಲ್ಲ, ನಾವು ರಿಜಿಸ್ಟ್ರಿ ಅಲ್ಲ, ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು, ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು, ಅಲ್ಲಿ ನೀವು ಮೊದಲು ಇದನ್ನ ಕಂಪ್ಲೈ ಮಾಡಿ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಾವು ಮಾಡ್ತೀವಿ ಅದೇನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ. ಅದಕ್ಕೆ ನೀವು ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ಬೇಕು. One more office objection is, you have to respond to it in writing. Office objection if it is not tenable.